Good evening, everyone. The June 10th, 2026 Arlington County Board of Zoning Appeals hearing is now in session. I am Richard Kaplan, Chair of the Board. The board is made up of 5 citizens appointed by the Circuit Court. Tonight, in addition to myself, we have members Inta Malice, Judy Freshman, Carol McCoskry, and Alex Kumana. Also present is the professional staff, including Lindsay Klein, BZA Coordinator, Meg Ryan, BZA Associate Planner. Joining us virtually is Brett Goldberg, BZA Associate Planner, and I assume Stephen Rissy is here, but I don't see him online at the moment. Only not because he's not here, but I just can't see everyone. To avoid disruptions, we ask that you please place your mobile devices in silent mode. Before we begin tonight's hearing, I will discuss this board's powers and procedures for tonight's hearing. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county's zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests solely with the county board. This board does have the authority to do 3 things. First, the BZA can approve use permits that allow modifications of placement requirements for structures on 1- and 2-family lots where there is no option in the zoning ordinance to allow such modifications. In order to approve a use permit, the Arlington zoning ordinance requires that this board find that the proposal will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, and will not be in conflict with the purposes of the master plan and land use and zoning related policies of the county. In making these findings, the BZA shall consider whether the modifications will promote compatibility of the development with the surrounding neighborhood because of the structure's overall size, placement, and footprint are similar to those of the structures on the property surrounding the lot in question, and whether that modification will help preserve natural landform, historical features, and/or significant trees and foliage. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary and in the public interest, including but not limited to the duration of that use permit. This board does not have the authority to grant use permits to modify the requirements for expanded housing option developments. Second, the BZA can grant variances from the specific requirements of the zoning ordinance. When granting variances, the burden of proof is on the applicant to prove by a preponderance of the evidence that the strict application of the ordinance would unreasonably restrict the utilization of the property, and the need for a variance would not be shared generally by other properties, and such variance is not contrary to the purposes of the ordinance. Or that the strict application of the ordinance would unreasonably restrict the utilization of the property, or that granting the variance would alleviate a hardship due to a physical condition relating to the property or improvements thereon at the time of the effective date of the ordinance, or would alleviate a hardship by granting a reasonable modification to a property or improvement thereon requested by or on behalf of a person with a disability. In all variance cases, the property for which the variance is being requested must have been acquired in good faith, and any hardship must not have been created by the applicant. That the variance will not be of substantial detriment to adjacent properties and nearby properties in the proximity of the geographic area. That the condition or situation of the property concerned is not of so general or reoccurring a nature as to make reasonably practicable the adoption of an amendment to the ordinance. That granting the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, and that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning or subdivision ordinance. Third, the BZA shall hear and decide appeals of the zoning administrator or from any order, requirement, decision, or determination made by any other administrative officer in the administration or enforcement of Title 15-2, Article 7 of the Code of Virginia. In exercising its powers, the board may reverse or affirm wholly or in part, or may modify an order, requirement, decision, or the determination appealed. The determination of the administrative officer or zoning official shall be presumed correct by the BZA. The appellant has the burden of proof to rebut the presumption of correctness by a preponderance of the evidence. The board shall consider any applicable ordinance, laws, and regulations in making its decision and must base our judgment on whether the administrative officer was correct. The concurring vote of a majority of the membership of this board is necessary to reverse any order or determination. Now on to tonight's hybrid hearing. For those who are participating in the room, on the front of the table, you will find a QR code linking to a copy of the application package, including the staff report for each case before us this evening. For those participating virtually, a copy of each application package can be found on the Arlington County BZA website. There is also a link in the chat for the application packages. If you have not yet seen the report for your case, you should review that report before your case is called. If you are attending virtually and lose connectivity, please reconnect with us by phone. If you are attending via Teams, please keep yourself muted and cameras off until called upon. Turn off the sound on any other devices around you to minimize interference. When called upon to speak, please turn on your camera and unmute yourself by clicking on the microphone icon that is located in the meeting command bar. County staff does not have the ability to unmute you. The meeting chat is active for technical support assistance only. The meeting chat should not be used for discussion, public comments, questions about agenda items, or requests for more information. All public comments must be shared verbally or have been previously provided in writing for the record during the assigned testimony period. This evening, staff will call each case and will provide a brief staff report and recommendation. Next, board members will ask any questions of staff that they may have. Applicants or their representative will be given an opportunity to make comments to support the application or appeal. Next, all speakers for items will be called. Speakers must fill out a speaker slip, which is either online or is available on the table in the front of the room. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may ask questions of any speakers, but does not permit any cross-examination or direct questioning by others. For tonight's hearing, this board has deemed the following time limits for speakers: 20 minutes for applicants of appeals, 5 minutes for applicants of use permits and variances, 3 minutes for representatives of organizations, and 2 minutes for individuals. After the board has gathered all the information we need and have discussed the case, we will decide the matter by voting on a motion duly made and seconded. A majority of the membership of this board is needed to approve any motion. Please be respectful of the time allotted. This is a public forum, and tonight's hearing will be recorded and posted on the county's website. All information associated with tonight's hearing, whether spoken or written, is subject to the Freedom of Information Act requirements. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. After your case of interest is heard, you are welcome to stay for the balance of the session or leave at your convenience. I don't believe we have any matters to attend to before we get started, and I think the first item on the agenda is an appeal.
Happy to read the first item.
Please go ahead.
Case number V-12115-26-APP-1, an appeal by Nicole and Matthew Altomar of the Zoning Administrator's decision to approve expanded housing options EHO permit number ZEHO 24-00033 for a lot located in the R6 zoning district on the premises known as 3812 16th Street South, RPC number 26-011-017, Douglas Park, ZAPP 26-00004. Did I say the number? Enough zeros? 4 zeros. And then 4. Staff recommends that the board adopt the attached proposed resolution affirming the zoning administrator's decision. Please also note that we have an additional speaker who has signed up to speak on this item.
Thank you, Ms. Klein. Are the appellants in the room? Excellent. So generally, we start with the county to present their recommendation or view, and then we'll go to the appellant and then speakers, and then we'll entertain questions from the board. So Ms. Baum, are you taking over?
Yes. Good evening. For the record, my name is Arlova Baum, Zoning Administrator. If you could advance, yes. So just to remind everyone, the appeal today is for an expanded housing option permit issued February 27th that approved a 6-unit multifamily building. The appellants contend that the permit was issued in error on several grounds, stating that the proposal did not meet all the provisions in Article 10.4. I just wanted to remind the BZA of the standards of review for appeal, which state that the decision on an appeal shall be based on the board's judgment of whether the zoning administrator was correct, and the decision of the zoning administrator shall be presumed to be correct. The appellant's materials often cite instances where they express concern that a standard may not have been met, but it is their burden to show that that hasn't happened. Next slide. So the next several slides will address each of the appellant's grounds individually. So the first one addresses the minimum parking requirements for EHO development. The zoning ordinance at section 1046A provides that EHO development near transit has reduced parking rates. And for properties within a half mile of a premium transit network stop, the required parking ratio is 1/2 space per dwelling unit. Columbia Pike is a designated premium transit network on the Arlington County Master Transportation Plan. And the map on the screen indicates the location of transit stops along Columbia Pike as shown with purple dots. The shaded blue area represents a half-mile radius from each, and the red marker is the approximate location of the subject property. As shown on the map, the property is fully located within the area for which required parking is 1/2 space per dwelling unit. So for a 6-unit building, the requirement is 3 off-street parking spaces. The site plan in the approved permit plan set shows 3 proposed surface parking spaces on the subject property, and therefore the proposal is compliant with minimum parking requirements for EHO development. Next slide. The second ground relates to gross floor area requirements. The appellants cite a discrepancy between the gross floor area listed on the initial EHO application provided by the applicant and the final approved gross floor area shown on the EHO permit. While appellants concede that both numbers meet the EHO requirement for gross floor area, which is 8,000 square feet for a 6-unit building, they point to the 2 different numbers as evidence of possible errors. Applicants supply information that they believe to be correct at the time of the permit application. However, professional zoning plan review staff, many trained in such disciplines as architecture, planning, and civil engineering, review the documents and materials submitted to determine if a project meets the requirements of the zoning ordinance. As such, it is not uncommon for an applicant to provide figures that differ from those calculated by staff. The gross floor area provided on the EHO permit and shown on the approved plan drawings is 7,598 square feet, which is consistent with the zoning requirements for EHO development. Next slide. The third ground points to no specific error, but instead refers to the EHO permit cover sheet as being insufficient to demonstrate compliance with zoning requirements for EHO development. Appellants, for some reason, completely ignore the approved plan drawings associated with the project and cite a lack of information on this single sheet as being evidence that the project is not zoning compliant. As previously stated, trained professional staff review and analyze the drawings and materials submitted in permit requests against zoning ordinance requirements. The physical information needed to assess compliance is provided in the 13-page set of drawings that were stamped and approved. The EHO permit is a cover sheet with selected summary information about the project. Appellants do not cite one area where zoning compliance has not been met and have not met the burden of proof required given the presumption of correctness per the Code of Virginia. Lastly, the powers of the BZA do not extend to requiring an independent review of EHO materials. And the project is compliant with the dimensional and site development regulations found in section 10.4. Next slide. Ground number 4 relates to pre-application consultations. The zoning ordinance does not require pre-application meetings or consultations for EHO permit applicants. It is, however, a service that the county provides to assist those who have questions about the process. While the EHO applicant did not request a pre-application conference, this is not required to approve an EHO permit. Further, appellants do not cite a zoning requirement that has not been met, and therefore this project is in compliance. Next slide. Ground number 5 cites the Nordgren case as an impediment to properly reviewing and approving the subject EHO permit request. As stated, the EHO permit application was initiated in August 2024, and staff review had not yet begun by the time of the first Nordgren ruling in September 2024. As a result of this ruling, the EHO permit application was voided and no work commenced on the permit for over a year. When the Court of Appeals reversed the prior court decision in September 2025, staff unvoided all applications that had been previously submitted, and staff review of the permit did not begin until December 2025, well after the EHO ordinance had been reinstated. The EHO ordinance has been valid continuously since September 2025, and therefore the EHO permit was properly reviewed and issued as being compliant with the zoning requirements for EHO development. Next slide. The next 2 grounds for appeal were not included in the original appeal application submitted on March 26, 2026, but a month later on April 27, 2026. While appellants asserted their right to add arguments to their appeal, the statute provides no such time extension. Staff believe that supplemental grounds A and B were not timely and should not be considered by the BZA. Nonetheless, we have provided responses to each. Supplemental ground A references a Code of Virginia requirement for notice to property owners for zoning decisions made when requested by someone other than the owner or their agent. Staff believe this requirement is not applicable because the application was made by the project architect acting as an agent of the property owner. Despite the fact that property ownership has changed since the time the application was submitted, the same architecture firm remains working on the permit requests at the behest of the current property owner. Further, the appellants are not the property owners and have no ability to enforce third-party property rights on their behalf. And lastly, the subject EHO permit runs with the land, not with an individual owner. Next slide. Supplemental ground B incorrectly applies public notice requirements for special exception uses to a by right zoning approval. EHO development according to the Arlington County zoning ordinance is authorized by right, meaning that if a project meets stated criteria, it may be authorized administratively, as opposed to special exceptions which require public hearings and approval by either the county board or BZA. The only EHO development projects that require special exception approval per section 1044B are those on parcels that exceed 1 acre in size. As the subject property is 10,688 square feet, this requirement does not apply, a special exception is not required, and neither are the public notice requirements associated with special exception requests. The proposal is zoning compliant. That concludes my comments. However, I believe the current property owners may be attending virtually, and they're free to make use of the rest of my remaining time if they choose.
Thank you, Ms. Baum.
Yes. Hey, good evening, everybody. It's Sumit Murugai. Yes, so I just want to tell you, I think whatever was said in the last 10-15 minutes is absolutely correct. And we were aware and authorized this EHO permit, and there's nothing else I want to add. So, but thank you for this and very well presented. I appreciate. Thanks.
Thank you. Are the appellants Mr. and Mrs. Altomare? Yes, and there's also there's some arrows on the podium to raise it up as well.
Can you hear me? Okay.
Yes.
Good evening. My name is Matthew Altomare, and with my wife, Nicole Altomare, we own and live at 3806 16th Street South, immediately next door to the subject property. Thank you for hearing us tonight. We understand your role is narrow to decide whether the zoning administrator was correct, and we are not asking you to rewrite the ordinance, to resolve the broader missing middle litigation, or to substitute your policy judgment to the county boards. We have studied the staff report carefully, and we want to engage with it honestly. One thing I will note, just in sort of response to the presentation that was just made in terms of the original ground 3 of the appeal that we submitted on time, it references the 13-page set of stamped documents. Please let the record show that that information was not available at the time that we had filed that original appeal, as we had sent a FOIA request to receive it and had not received the response by the time we submitted that original appeal. So just wanted to note that timeline for the record. Let me start by narrowing the issues, because candor serves this board better than overreach, of course. On gross floor area, we accept staff's explanation. The figure on the application was the applicant's preliminary number. Staff verified the final figure through its own review, and that is under the cap. We do not contest that the gross floor area complies. On parking, we accept the ordinance permits the reduced rate for sites with a half-mile radius of a premium transit network stop, and that radius means a straight line measurement. Measured that way, we recognize the property likely falls within the radius. We're not going to ask this board to read the word radius, quote unquote, to mean something other than what it says. We narrow the issues this way deliberately so the board can focus on the one matter we believe genuinely warrants its attention tonight. We want to raise one factual matter that bears on how carefully this file should be examined, and it raises a discrete question that the available record may not answer despite what has been said tonight. We understand the county's position that an EHO permit, quote, runs with the land so that a later change in ownership does not by itself affect the permit. We don't dispute that principle, but a permit can only run with the land if it's validly issued in the first place. The doctrine presumes a valid permit. It does not cure a defective one. And the presumption of correctness this board applies works the same way. It attaches to determinations the zoning administrator actually made on the record. Where the record contains no such determination, there is nothing to presume correct. With that in mind, here are the facts that we understand them to be, and they come from the county's own records, many of which were discussed tonight. The permit names the property owner as Pacific Homes, LLC. The approved civil plans revised in both 2025 and again in 2026 likewise list Pacific Homes. But the assessment record within that same file tells a different story. It correctly identifies the owners as Sumit Murgai and Anjali Munjal, and it shows the conveyance from Pacific Homes to them on November 8th, 2024. So within the county's own system, the permit side ownership information and the assessment side ownership information do not agree. Permit names a company that the county's own records show had not owned this property for over a year. This inconsistency was never reconciled. We've read the staff's report, and of course it was discussed right here tonight in the previous presentation. The staff states that an architectural firm was the agent of both the prior and current owners throughout. The Virginia Code section 15.2-2204 subsection H is therefore inapplicable, and that the notice right under that provision belongs to the owners, not to us as neighbors. I want to be precise about what I'm accepting. I accept that if the firm was the agent of the actual owners at all relevant times, the notice obligation was never triggered. And we accept that any notice right would belong to Murgai and Munjal, not to us. I'm not asking the board to enforce that statute or a right that is not ours. Our question is narrower. Section 15.2-2204 subsection H is satisfied in one of two ways. The applicant is the owner or the owner's authorized agent, or if not, written notice is given to the owner within 10 days, with evidence of that notice placed in the file. The record before us reflects staff representation that the agency relationship existed and an application form on which the submitter is checked as owner's agent, but the materials before this board do not appear to contain the underlying documentation. It should be an authorization for Murgai and Munjal, the actual owners during the review that led to the 2026 approval, as distinct from Pacific Homes, the entity named on the permit plans. Nor do they appear to contain evidence that the alternative written notice to the owners within 10 days was in fact given. So we ask only this. The staff confirm on the record that the permit file contains documentation of the applicant's authority to act specifically for Murgai and Munjal during that review, or it does not. The evidence of notice the statute requires. If that documentation is in the file, the question is resolved. We accept staff's representation. We ask only that the representation rest on a determination in the record rather than on the face of a permit that names a company the county's own records show no longer own the property to ensure the presumption of correctness has been fully earned. Much of what troubles us about this approval is not, we recognize, within the board's authority to remedy. We want the record to reflect that we are reserving those concerns for the county board in the proper venue. We believe transit proximity should be measured by the actual distance a resident must travel on foot or by vehicle, which we believe for this property exceeds half a mile, rather than by a straight line radius. We believe adjacent neighbors should receive written notice of EHO applications and approvals. We received none. Furthermore, appellants should not have such a high fee to file an appeal. And we believe larger corner lots rather than narrow interior lots like this one are better suited to absorb the parking, traffic, and massing of a 6-unit development. These are matters for the ordinance itself, and we have already raised them with the county board. We mention them here only to preserve them, not to ask this board to act on them. In closing, we have tried to bring you a focused and honest appeal. Our remaining concern is the ownership discrepancy, and on that point, we ask only that the board confirm on the record the file contains documentation of the applicant's authority to act for the actual owners during the review that led to the approval. We're asking you to please look closely at one genuine irregularity before 6 units and the significant disruption that they will bring during construction and afterward are approved next to our single-family home. Thank you for your time and your careful attention this evening.
Thank you. Let's hear from our signed up speaker, and then might call you back for some questions. So, Mr. Antipas, did I get that right? Sweet.
Lights on.
Lights on. You're good.
Hi, everyone. My name is Alexander Antipas. I am a nearby homeowner on South Pollard Street, about 6 or 7 houses down from the subject property. I just am here to raise concerns from myself, my wife, and many of the local neighbors who are going to be affected by this large 6-unit property that is being proposed to be inserted into a very narrow lot on a street that clearly has infrastructure that is not equipped to handle 6 families. I understand that the zoning requirements only are requiring 3 parking spaces, but I think we all need to just accept that it's a little bit unrealistic that 18 residents are going to, only require 3 street parking spaces. Let's also take into account how many garbage bins, simply like 18 garbage bins for 6 units are going to be located on this very narrow lot where there are also supposed to be 3 parking spots. I just think that it is very inappropriate for this particular development to be sited in this particular location. And I do think that it reflects shortcomings in the application process. May I finish? And I do think that, this does set a pretty bad precedent where it is going to be very disruptive if this project is allowed to proceed, and it really will detract from the ability of the neighbors to use and enjoy their property. And I echo all of the restate all of the comments made by the appellants, and I think that the concerns they raise are worth your consideration, and I urge you to grant their appeal. Thank you.
Thank you for your comments. Do my colleagues have questions for staff? Ms. Malice.
I wonder if, I'd like to just make sure I understand the issue with ownership. So I wondered if staff could sort of describe what their understanding of the ownership is and how that impacts the application.
I never can do this. If we could turn to the,
I'm sorry, could you introduce yourself?
I'm Ann Golsky with the County Attorney's Office.
Thank you.
And I think if we could turn to the page of the presentation which is labeled response to ground number 5. I think we tried to lay it out here on the little chart to the right. You can see, I think we put when the property was conveyed to new owners. The ownership of the property really is not extremely relevant to the process because, as we said, as in the presentation, that the permit runs with the land itself, not the property owner. And the agent stayed the same for both property owners. So it was the architect for each property owner. So we laid out the timing of the sale of the property there for you. As you heard the current property owner say, they authorized the agent, the architect, to make, they were aware of the EHO permit and they authorized the agent to be the agent for the EHO process, which is what we heard tonight, the board heard this evening.
So can you sort of summarize what your understanding of the applicant's concern is?
I think you're going to have to ask the applicant what the applicant's concern is. I don't understand
I'm
it.
having a little trouble understanding your response. So the appellant is making the case because the ownership changed.
Yeah.
At some point in the process, that the process at some point became invalid.
I think that may be what they're saying. I don't understand their argument. It doesn't make sense. It doesn't have any legal justification. I would suggest you ask the appellants what their argument is.
So from your standpoint, the process of reviewing the permits or from staff's, who actually owns the property at any point in the permitting process is irrelevant.
We need to work with the proper agent. That's relevant. And we were working with the proper agent.
Okay.
If that's your question. We definitely need to be working with the proper party. And we were, because we were working with the agent of the property owner at all times.
So, and
It was the same agent for both property owners. Ms.
So-
Cashman.
so both property owners designated the architect as their agent.
Yes.
Thank you.
Well, we'll have questions for you, and then at that point, we can call you up. Let us finish.
Ms. McGrath.
Go ahead.
So, and I think this is what the applicant said. Was there documentation written documentation in the file? And I'm not saying that's necessarily required because I don't know that it is, but was that documentation authorizing the agent to be the agent of the new owners? Was that ever in the zoning file in writing? Because I know there's a form for that when you authorize somebody to act.
So
Sorry,
it's when the application is initiated, the applicant kind of checks a box. And because this was kind of on again, off again, we didn't make people reapply. So it never changed. So there was no additional documentation other than the assertion at the beginning of the process. If you're looking for like a piece of paper.
Right.
Yeah.
But I guess it would be correct to say that or is it correct that at all times the agent was the person in the form that was done
Correct.
initially? Okay.
Yes, that never changed.
And I would add, just, there is no requirement for, the paperwork. It's throughout the process. And it was made clear, obviously, who the agent was, and the discussions were, who they were with and who the agent was. And that continued through the whole process.
So in many of our cases, we have somebody sign a form saying that they're the agent for the owner. There was no second form signed saying that the agent is now the agent for the new owner.
There was no first form signed. We don't require a signature. Right? They just fill out an application and they self-certify that they are an agent.
It's the application that we normally see,
Correct.
right? So there's no second application.
No.
The agent self-certifies.
Yes.
And in this case, I assume that there was no like second certification because the application just continued.
Correct.
Because the agent still.
Because the agent is still the agent,
The
right?
agent
So
is
I mean,
still
I suppose that if I'm not sure what would be gained by an agent continuing a project on behalf of someone they didn't own, because at some point that would get caught,
Correct.
right? So my kind of question is going to the like extreme logical end here. If this board sides with the appellant and overrules the zoning administrator, then the homeowner agent can then refile for another EHO appeal, another EHO permit, and then it would presumably be reviewed by staff over again. Right. I'm just not. I guess I'm just not sure what the effect of this appeal is, and there's nothing that would prevent this homeowner from trying to get another EHO permit with the proper
Correct.
assertion.
I don't see. You can answer.
I don't, I mean, I guess a cap of, if there was a cap, they might be prevented. I think the important part to remember is that there is evidence before this board that was testimony that,
No,
and there is
I'm
no written authorization required to be in the file. I know that appellants want very much for there to be such a requirement, but there is no such
And
requirement.
my comment should not be read into
Gotcha.
any way. I'm just kind of, what's the end result here? I'm not, might be a delay of a few months. I'm trying to figure that out, right? I'm sorry, Ms. McCaskey, were you trying?
No, we're going to move separately to have questions for the
Definitely,
appellant.
yes.
And I think some of those go to
Yes.
what the appellant's contention is. So, but we'll get there.
Anything further for the county? Appellants.
Yeah, I'd be interested in
I would like
hearing the rebuttal.
Yeah, I would be happy to, if you would like to respond to anything that you have just heard from
And
everyone.
If I could, I mean, I think the important point is what is the error that was made in the process by allowing the agent to continue with the new owners?
Sure. So I'll just reread part
Can
of
you
this.
hit the button on the microphone?
Here, hello. Okay.
Better, thank you.
Thank you again for additional time. I'll briefly reread a section that I think is most applicable here as part of our statement. So it goes back to section 15.2, 2204, subsection H of the Virginia Code section, which is satisfied in one of two ways. The applicant is the owner or the owner's authorized agent, which, yes, we acknowledge that the current owner said that in the room tonight. But other than the original application, which was a different owner back in August of 2024, there is no other documentary evidence that that was in fact represented before tonight here in person verbally. And that's key because if that's not in the documentary evidence to sort of prove compliance with that section of the Virginia Code, then written notice must be given to the new owner within 10 days with evidence that that notice is placed in the file. So we're not disputing the statement by the current owner that was said here verbally in testimony tonight. And sort of some of the assertions here, we're narrowly focused on the fact that the documentation to our knowledge, and we haven't heard anything respectfully that's been uttered tonight, that it ever existed before in the file itself. And so we think that without that documentary trail, we have questions about the compliance with section 15.2, 2204 subsection H.
But so, and as I understand it, the application in this was filed by the agent, identifying themselves as the agent. And that's the party that continued to move forward with the process. And we haven't, is your argument is that you don't know whether the notice was given to the owners within 10 days?
The new owner, which changed November 8th, 2024.
Well, okay. But what this says is within 10 days of receiving the application. So that would have been with the original owner, not with the new owners. Nothing says we have to, when the ownership changes, you'd have to do it. So I'm just, and I recognize I'm sort of making an argument, but just to give you the opportunity to respond to that, because the original notice, this notice would have been within 10 days of receiving the application. The application was received a month before the ownership change. So that would have been given to the original owner, right? That notice to do within 10 days.
That would be our understanding, but I think without documentation of that regard, or the relationship of the new owner, or the fact that kind of earlier in my statement, I pointed out that the ownership of the signed documents is actually incorrect. It's sort of, we have some questions about the documentary trail here in terms of actually proving this out.
And does that affect your, property interests in any way other than there's just potentially some procedural thing that may or may not be in the documents? I'm just wondering how that affects your all's interests, other than the fact that you would like to not have this development.
I think as a citizen of the county, generally speaking, we have general interest in ensuring that if a permit is approved, it's approved in compliance with our understanding of the existing code and the measures required therein.
Is there anything further?
So would it then be your contention that a new application should have been filed?
Admittedly, I don't necessarily want to get into sort of hypotheticals of what should happen instead. I am attempting my level best as a citizen to represent what I think is the existing discrepancy.
That's the logic is, that the agent applies on behalf of an owner. And then the owner changes. It does somewhat suggest that there would have been some kind of a notice or a change, some kind of a reapplication. From what I understand, staff's argument is that that was not necessary. And I'm not sure if the law, if that ordinance backs the situation up one way or the other. But it's just it's logical that, an agent was acting on behalf of one owner. And now is he acting, there should have been some kind of communication if the agent is now acting on behalf of another owner. Whether that's a fatal defect, I don't know. But
I'm looking at 15.2 H, and I'm just having a hard time seeing how it applies here.
okay.
Right. When any applicant requesting a written order requirement decision determination from the zoning administrator is not the owner or agent of the owner of the real property, then notice shall be given to the owner of the property within 10 days. And so in this case, if the agent wasn't working on behalf of the owner, then I guess the county was supposed to give notice to the property owner. And so now we have a third party who's trying to enforce that notice requirement. And so I'm just having a hard time seeing what the rights here are that we're missing. It seems like if there is an agent working on behalf of a property owner, which is not the case here. That isn't the property owner. That's between the county, the property owner, and the agent, not the neighbors.
I'm not asking you to rule on the standing. I think we're just asking for evidence of it in the documentary record that in fact is what took place.
Okay.
So when you say that's just what you're asking for, but you do believe that it's a fatal defect.
Ma'am, I would offer that, and I think this was mentioned articulately at the beginning, that this presumption of correction underpins the whole ruling. So we are offering from our perspective a potential issue with the overall presumption of correction of the file based on the narrow issue that we have raised.
Anything further, Ms. Malice?
No.
Thank you.
Hi, everybody. This is Suresh Burnham, the owner of Pacific Homes. I'm the sole owner of Pacific Homes. Is it okay for me to add one or two points here? I'm a registered speaker as well.
I think that the positions are clear, and I think that we are ready to discuss and issue a ruling. But both sides have had fair time, and I think that we're ready to close this matter.
Sure, thank you.
Thank you. Would anyone like to discuss or make a motion, Ms. McCoskey?
Well, first of all, I want to note, Mr. Altamar, I mean, I think I pressed you on some of these details and all, but really, it was a great presentation, I think. I mean, I think that I just want to commend you on having brought these things to the attention of the BZA, because I think that, you know, as a citizen, you did a great job of presenting that. I want to make sure that doesn't get lost in us picking at the details, as we like to do. I do think that I think one thing that's a little difficult here is that we do have this process for the matters before us of where an applicant or expressly signs a documentation authorizing somebody to be their agent. And that clearly isn't the process. And it's not a necessary process unless someone made it such. But I think that's not the process in the county's applications for these. And they accept the request from the agent. So I think that is a difference in the processes, but I think that's not a problem of a difference. And I do think that given what is determined at this level of the EHO process, the permit was properly issued by the zoning administrator. So that'll be my position. And I guess I can make a motion, but I assume other people might want to have something to say.
Thank you, Ms. McCoskey. Mr. Kamana, please.
Yeah, I echo everything that Ms. McCoskey said. I'm sympathetic to what the appellants are kind of going through. It seems like this property's kind of changed hands a few times. Based on like what I saw online doing research, like it might change hands again. So their neighborhood has a lot of, you know, kind of just limbo, and that's probably very frustrating. This isn't, and I recognize this isn't really a townhome or you know, this is something a little bit more, you know, invasive is not the right word, but you know, it's going to change a lot of like how they have lived in their street. So I'm sympathetic to that, but I do kind of go back to, well, I have to go back. I think we all have to go back to, you know, what we're unilaterally here to do, which is not to, you know, enact or, you know, create public policy, but to determine whether the permits were issued according to how they were supposed to. So I'm also going to vote how Mr. McCoskey stated, but I appreciate what you all came and how you all spoke to us and what you're going through. I really do.
Thank you, Mr. Kumana. Would anyone like to make a motion?
I move that the Board of Zoning Appeals uphold the decision of the zoning administrator in matter V 1211526 APP 1.
Second.
A motion made by Ms. McCoskey upholding the decision of the zoning administrator, seconded by Ms. Freshman. Is there any further discussion? I'll just say, as I normally say, we've been through a whole bunch of these appeals. And each one of these is I think it's very difficult for all of us because we have to put aside our personal feelings on a particular project. This appellant has righteous grievances, and he listed them with the high fees of the appeal, distance of this property from transit, the lack of notice for these big projects that happen on neighbors, the parking requirements. I mean, we can go the trash bins. We can go on and on and on. I think that they are fair and just grievances, but this has been an ordinance from the county board, right? And so once the county board issues the requirements for these for these projects, our role here is very limited in determining on whether the zoning administrator erred in her decision, and if so, she's given the burden of presumption of correctness, which is a very high standard. And so while I really feel for the applicants, and I would not want to be them in this case either, I think that, as my colleagues have kind of alluded to, that our hands are really tied here, despite how we, any personal feelings we may have to a particular project. Anything further?
I'll just say
Ms.
that,
Malice?
yeah, I will vote with the majority, and I regret that this is your only recourse because it's not a very effective recourse to come before us.
Must
Because,
be utterly frustrating to be hearing what we're saying.
yes,
With that said, I'll call the roll. Ms. Malice,
aye.
Ms. Freshman,
Aye.
Ms. McCoskey,
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion to uphold the zoning administrator passes 5-0. Sorry. Ms. Klein, can you please call our next item on the agenda?
Yes, case number
Can we
V-120.
drop, if you don't mind, for the previous ones? Can we drop from?
Can you mute that? Thank you.
V-12087-25-UP-1 carry over and withdrawn. A use permit request carried over from the January 21st, 2026 and March 18th, 2026 BZA hearings by Per and Erica Midbow, the owners, who have requested to withdraw their application that was previously sought to permit a rear setback of 2.5 feet to the eave instead of 10 feet to the eave as required, to permit a side setback of 1.1 feet to the areaway instead of 5 feet to the areaway as required, to permit a street setback of 23.3 feet to the building wall instead of 25 feet to the building wall as required along 6th South, and to permit a street setback of 18 feet to the porch column, 17.3 feet to the porch eave instead of 12 feet to the porch column, 19.5 feet to the porch eave as required along 6th Street South, regarding a one-story detached accessory building with basement and porch on a corner lot in the R6 zoning district on the premises known as 601 South Taylor Street, Barcroft. And staff indicates that the request has been withdrawn by the applicants, and no further action is required by the BZA.
Thank you, Ms. Klein. Can you call the next item?
Yes, case number V-12099-26-VA-1 carryover. A variance request carried over from the April 15th, 2026 BZA hearing by Douglas Hoffman, the owner, to permit a lot coverage of 43.5% instead of 43% allowed for a one-family dwelling in the R6 zoning district with a qualifying front porch, regarding a front porch addition to an existing one-family dwelling on a corner lot in the R6 zoning district on the premises known as 2626 North Harrison Street, Yorktown. Staff recommends that the board adopt the attached proposed resolution denying the variance request. An alternative resolution has been provided to the BZA see fit to approve the variance request as advertised.
Thank you, Ms. Klein. Do my colleagues have questions for staff on this application? Is the applicant with us? Would you like to speak again to your application? Please. I don't think it, yeah, it does not sound like it's on. Try it again.
Now? All right. So you can go to the next slide, please. I'm going to talk about the request. I'm going to talk about the existing versus the resulting conditions. I'm going to talk about staff's response, some responses I have, my reply, and then I'm going to do a very quick comparison. I'm going to, like I said, I'm going to move really fast because I have 5 minutes. I respect your time. I appreciate. And second, I want to say thank you for allowing me to continue this. I think we're going to have a more productive conversation about it, that having occurred. If I only had, well, okay, so the request is pretty modest, 43.5 versus 43 in that situation. In this situation, we're talking about 37 square feet. And the slide sort of lays out kind of the porch. Next slide, please. The slide kind of lays out the porch, the variance, and at the bottom there, like the porch and the variance, and sort of what I'm allowed to have by right, which is 50.1 square feet, which is a huge focus of staff. So if I only got one slide, next slide, please. If I only got one slide, this would be it. I think this is a fairly unique situation for the board to consider. So if we look at the existing condition right now without a variance, the overage is 0.3% on the main building footprint. Lot coverage overage of 2.3%. Okay, so now if we go to a variance, we actually become compliant with main building footprint at 31.4%. Okay, and lot coverage overage is at, as I'm sort of asking for, 0.5%. Okay, but that's a 1.8% reduction in overage. The property's over now because it was built in 2004 before the 2005 amendments. Okay, so it's over in both categories now. With the variance, it would only be over in one, and the one that it would be over in, the variance would be less. Okay, and it would have a county incentivized front porch, right? The county has said if you want a front porch, you get 3% extra coverage. You get all of these ability to do that, right? That is and what I'm hearing a lot last time and a lot tonight is this idea that like we're sort of constrained by the county. Well, the county has been very clear on this. They want porches. Okay, so the next slide, I'm not really going to spend a lot of time with it, but if you really boil down staff's report, this is their report, right? These are their sort of statement, and basically what their statement is, hey, sir, you can still build a porch. Like you have 54.1 square feet, build your porch, right? And that's really the crux of it. So next slide, please. So I don't think. And look, staff is totally entitled to their position. They've been incredibly professional and incredibly helpful throughout this. This isn't about staff. But I do think that there are some things that perhaps, you know, I see differently, which is there are existing physical aspects of the property, you know, that were in place when I took over the property and when the new ordinance was put into place, right? So, for example, the property has a front door. The front door is in a existing location. In order to have a front porch, you have to have an entrance on it to the front door. That front door is over a certain amount on the property, and that creates a porch of a certain size or a requirement for a porch of a certain size. If we go to the next slide, please. So these are the windows to the left of the house as you're facing the front. They haven't said this. I want to be clear. I'm reading into there, but what I feel like staff is saying to me is, sir, you can build a porch with 54.1 square feet. So just terminate your porch, I guess, somewhere between those windows, and you'll have your porch. That's what I'm sort of interpreting their thing to say, but I don't really think that's a super viable porch. I think the word they use, I had it back on another slide, design aesthetic. So actually, and there's one other thing I'd like to point out about this slide, sort of another, what I would consider an improvement issue, like an existing feature of the improvement. You see how the stoop has the front door and it's brought out a little bit. And then, that's about, I don't know, I want to say 18 inches, and it goes over a certain number of feet. Like, I would love for my house to just be flat there. And that way, I could have less, I would be asking for less space, right? And we would all be happier. I will say that wouldn't bring me into compliance. It's not enough. But it's an existing aspect of the home. It's an existing aspect of the improvement that, from my point of view, is hindering the design of the porch. You will see the porch has 2 chairs on it. I'm not really asking for some, massive, grandiose porch design, and there are more pictures about that later. So let's go to the next slide, please. And this is I've already talked about this one. It goes to like window placement and the idea, the oddity of what a porch would look like if you were to terminate it between those 2 windows. And if you go to the next slide, I did a quick walk around my neighborhood while walking my dog. And, this is what porches look like. They terminate at sort of architectural stopping points in homes, be that a garage, be that another outlay, like another, jutting part of the house, something like that. Most of them, if you see like all the ones to the right, the 4 to the right, they terminate at the end of the house. And that's all I'm really asking to be able to do. I don't really feel like that's a design aesthetic. I feel like that is sort of a porch. I'm out of time, but I will keep going. Okay, next one. This is the physical property of the yard. This is my only slide on that. The yard has a very high hill. Staff sort of has suggested that, well, sir, you can use your front yard. You can just sit in this part and look out onto the street, which I can't see because I have a huge hill in my front yard, very steep. Just one more slide and then I'll just stop, even though I'm not done. I appreciate your time. I'm sorry I'm running over. I think this is really important. This is the design that my neighbors said yes to. Okay. And so it kind of goes to what I was saying before, which is nobody terminates a porch between 2 windows because they only have 54.1 square feet. And I wouldn't do that to my neighbors because I feel like it would be odd. It would not be in keeping with the consistent theme of sort of how porches are done in the neighborhood. So I think out of respect for your time, I'm going to stop there. I appreciate you allowing me to go past my time.
Thank you. Do my colleagues have questions for the applicant? Discussion with the board? Ms. Malice.
I can go first. I see 2 options here. We either the applicant builds a reduced size porch, or he reduces coverage someplace else on the site. What I'm hearing is that the desires really naturally, probably, but nevertheless, kind of center on design decisions, and design decisions really are not criteria for a variance. The variance standard is pretty high as far as hardship goes, and I don't think that a design decision meets that criteria.
Thank you, Ms. Malice. Go ahead.
I'll just speak briefly. This is difficult, but I do think there are specific standards for when we approve variances. And I think we don't have an unreasonable restriction. We have something where an ordinance, a general recurring ordinance change could fix this. I understand it's a situation where you have a house that was a certain way when you bought it, and it puts you in a difficult position, but I think that's right. And the two options that Ms. Malice mentioned are there, and they neither of them requires a variance. But I think the other problem that I have, there's an ongoing problem of people wanting deeper front porches than is generally allowed around the county. The county says you can have your front porch can encroach 4 feet. That makes a porch that's 4 feet wide or deep. It's not very deep, but that is sort of the countywide standard that's in the ordinance, and everyone comes to us wanting 6, and this is even more than that. So unfortunately, even though I have a lot of sympathy for the applicant, I feel like it just doesn't meet the variance standard. And that's where we have to come out.
Thank you, Ms. McCoskey. Would someone like to try a motion?
Mr. Chairman,
Ms. Malice?
I move that the Board of Zoning Appeals adopt the attached proposed resolution denying variance V-12099-26-VA-1.
Second.
A motion by Ms. Malice for a denial as advertised, seconded by Ms. McCoskey. Is there any further discussion? Hearing none, I'll call the roll. Ms. Malice?
Aye.
Ms. Freshman?
Aye.
Ms. McCoskey?
Aye.
Mr. Kumano?
Aye.
Chair votes aye. Motion for denial here passes 5-0. Ms. Klein, can you please call the next case?
Yes, case number V-12116-26-UP-1, a use permit request by Christopher Durso and Helene Coryard, the owners, to permit a street setback of 10.5 feet to the building wall, 10.3 feet to the building eave, instead of 25 feet to the building wall, 21 feet to the building eave, as required from the 20th Place North right-of-way regarding a new 2-story addition to an existing 1-family detached dwelling on a corner lot in the R6 zoning district on the premises known as 1964 North Vermont Street, Waverly Hills, BZAR 26-00020. And staff recommends that the board adopt the attached proposed resolution denying the use permit request with conditions. An alternative resolution has been provided should the BZA see fit to approve the use permit request as advertised.
Thank you, Ms. Klein. Do my colleagues have questions for staff on this application?
Just a minor procedural question. When the recommendation says denying the use permit with conditions, there really aren't.
Yeah, in this case, there are none, so that's a great observation, and we can strike that.
Okay, so I just wanted to make sure there wasn't a trick here that we were missing. Thank you.
I have just a quick question for staff. On this application, there are clearly 2 easements that run through the front of this property. Do those easements prevent them from building on top?
Meg, can you speak to that?
I don't know for sure, but typically with easement, sometimes if work needs to be done, there might be things that need to be removed if they are in the way of the easement. So that could be a challenge.
And in this case, it's a sewer easement and a stormwater. Thank you. Yeah, so it would be written in the easement language itself and the property deed, what kind of the nature is. Okay, thank you. Thank you.
'Cause
Okay.
it looks like there's something built over the corner on the plat. Oh, okay. Okay, let's hear from the applicant.
Can you hear me? Oh, great. My name is Chris Durso. Thank you for hearing us. My wife, Ellen Carrard, and I have lived at 1964 North Vermont Street for 25 years. We have raised 2 children there who are proud graduates of Arlington Public Schools. We want nothing more than to stay in this house and age into place there and retire there. It's already a small property. We did a very exhaustive renovation and rebuild of it about 14 years ago. That was somewhat limited with what we could do to it because of the easements that run across the front of the property. In fact, we only actually bumped out the footprint of that by, I think, 40 square feet or something, if that. So now we're at a point where, as we do think about aging into place, we would like to make the house a little bit bigger and a little bit more comfortable. And to the point that was just raised, we are very constrained with how we can do that. We have 40.5 feet on our front lawn that we cannot build on top of. We have a small backyard that we would like to keep. And so the only option is to go out kind of this one side. And yes, it does in fact, it does in fact encroach on the setback, but it is still, it's a very modest project. It doesn't increase the square feet by all that much. And it is, we think, in keeping very much with the character of our neighborhood, which is, just tends to be kind of very quiet. And we do have the support and the sign off of all of our immediate and not quite so immediate neighbors. So that's kind of just a little bit more of the background. I'll let my wife talk a little more specifics.
Right. Thank you for hearing us today. In reading the staff report, it seems that the staff's only objection is with respect to compatibility with the neighborhood. And with that, really specifically, it says that the compatibility, that the placement would not be compatible with other two-story building walls on neighboring properties, right? So it meets compatibility with the style and the function of the neighborhood. In fact, if you saw some of the photos, but I also brought additional ones that I printed up. If I bring them forward.
So
this is,
I think what staff is alluding to with compatibility is that the distance from the two-story wall to the property line, which you are requesting of
10.5 feet.
10.5, thank you,
Yes.
10.5 feet. That's the compatibility that staff is looking for, is not that there's just a two-story wall elsewhere in your neighborhood. It's that wall is 10.5 feet from the property line.
correct.
Okay.
And I understand that it would be, and if looking at this map here, you all have, if you look at the other homes kind of around, they all have different variations of where they are on the side. I wanted to just bring 2 points. So in the photos that I brought, the rendering shows the fence stays where it is. The shrubs stay where they are. From the side, it doesn't appear any different. So visibly, it wouldn't look any different. And in the comparables that the staff pulled, 4400 20th Street North had an 11.5 foot to the building wall. Yes, that is 0.7 inches less.
0.7 feet.
0.7 feet, sorry, not inches. 0.7 feet less, but it is not appreciably different. And given that it matches with the structure and the feel in the neighborhood, and we retain all of our trees, and we can keep the quiet enjoyment of the home, we respectfully ask that this be approved.
Thank you. Do we have any questions for the applicant? Discussion. Ms. Freshman.
I am sympathetic to the staff's point of view, as is frequently the case. However, I think that the options for expanding are extremely limited, not the least because of the easement. So I would support the project if that's an option.
Thank you, Ms. Freshman. Ms. McGoskry.
Yeah, this is so frequently, these are not really easy decisions. And one of the issues that I have here is that, when you have a corner lot, the regulations, the setbacks provide that your open space should be provided on the street frontages, not in the back. And I understand completely you're not able to use the full front of your lot, but there is area in the back that could be used. And that's sort of where the placement of the bulk is supposed to go, on a corner lot. And that's kind of what, and obviously that's the issue here, is we want to put the corner lot, we want to put the space of the house on a corner lot in the side on one of the street frontages. And so I'm kind of struggling with the right thing to do would be to say, no, on this kind of property, it should go in the back. And I understand you've made a decision not to do that, but that's kind of where I'm trying to weigh things to come up with a good decision. Sorry.
If I can just, in the back, and
Mhm.
I saw that you've seen some of the photos, it's more evident. It's evident in the other photos. If you look at the previous slide I just had, right here, you can kind of see in through there, but we spent about 7 years ago, we built out that is all slate and flowers. And so it's really built out in order to add like kind of an external living
Mhm.
space. So that was our first attempt, like, okay, we're kind of stuck. How do we go? We really are, as my husband said, at the point where if our kids are going away and they're going to come back with families, we got nowhere for them to stay. We need to be able to have another bedroom. I mean, it comes down to that. So that is why we're asking in order to go to the side.
So was your design at all constrained by the easement? Are you
Yes.
building over the easement?
We are not. We are not. In fact, when we decided to do when we purchased the house in 2001, and it was a 1.5 story. And in 2011, we needed to expand, and we kept the existing footprint because of the easements. We couldn't go forward. So that's 40.5 feet. That's in the front. So, and the corner, right, where the stop sign is, allows full visibility. We didn't put any shrubs there either. You can see that to keep that open, but we couldn't go forward. So that bump out in the front that you see, that was actually a bay window. So we didn't really need to do anything in terms of, externally. And we went up. So we made the half story a full half story. So we really expanded as much as we could within that. Here, there's really, if we want to add another bedroom, there's really no way to do it with the structure of the house. I mean, yeah, we could go out 10 feet, but now we're over the crawl space entrance. 10 feet doesn't give you a bedroom. We have to reconfigure all the bathrooms. If financially, it doesn't make sense. And actually, it just wouldn't flow well as a house. So we'd have to rip everything out.
Excuse me.
Yeah,
So this plat that they're showing with the yellow, that wasn't in our staff report. Is
that plat attached to the application packet as the proposed certified plat?
There's a certified, yeah, there's the original plat on the left, but I don't see the one on the right. So that's why I was asking kind of where the.
Okay.
It's kind of a blow up of the first, the one after the certified plat that we have.
It's page 13 in the
I
application
see.
material.
But it's really, this is that's much. clearer.
I see. Okay.
I
got
struggled
you.
with figuring that out, and it's
Okay.
highlighted in yellow. So I agree.
Okay, so you're just missing the corner of that easement.
Yes.
Yes, and our architect has been back and forth with the city engineer about what we would have to dig the founding.
Just deeper.
Extra deep to basically not encroach in any way upon that particular.
And one correction on the staff report, it talks about a basement, but it's not a basement, it's a crawl space.
So, and what is I'm also, okay, so now I'm trying to figure out what's the depth of your backyard? Is that the 28.9?
On the existing plat, it has the building wall 28.9 to the rear
Yeah,
property
20,
line.
okay, so your existing is 28.9 and the rear setback needs to be 10 feet
Yes, for a corner lot.
for a corner lot. So you would have 18 feet in the back ending up with 10 to the fence. And the width of your current addition is, I'm having trouble. Do you know what the width of the current
I think it's
addition is?
10.2.
10.2. So it could go in the backyard, but it's really pushing up against the rear setback.
I'm torn on this one. This is,
Yeah.
when I was reviewing this one, over the week, this strikes me as one of these rare examples that I wish had come to us as a variance, because the standards are totally different. And while a variance is usually a higher standard, we don't have to find compatibility. We just have to find hardship as well as the other standards. And I think the easement to me would be a hardship. You can't do anything in that whole front of the lot. But I'm really having a hard time with the compatibility, because even if you kind of squint and you accept the 11.5 property that staff has listed in their staff report, the next one, and I don't have it in front of me, but the next one is like 17 feet. Like it's not even close to 11.5. So I'm really struggling with setting a new standard for a use permit if we grant this.
So,
Right, it's 11.5, right, to a 2-story building, and then the next one is 15 to a 2-story building. Right, so it's like, it's not even like the 11, even if we accept the 11.5, it's not even close to the next ones. But yet, like I said, I think there's a reasonable argument here for hardship.
yeah, I don't think we can use the word hardship, but I think there are mitigating circumstances here. I do think that the fact that this is set back so far from the other street, and the fact that you can't go forward at all, I think it is a factor in favor of their position. And by switching it to the back without any consideration of, design issues of just putting that block on the back, really does start to push the rear setback. So I have some sympathy here.
We can't do a bedroom that's 10 feet by 26 on the back. So, for what it's worth.
Do we have an alternative resolution?
We do have an alternative resolution.
In case V-12116-26-UP1, I move the alternative resolution for approval as advertised. With conditions.
A motion for the alternative resolution made by for approval as advertised, made by Ms. Freshman, seconded by Mr. Kumana. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice,
No.
Ms. Freshman,
Aye.
Ms. McCoskey,
No.
Mr. Kumana.
Aye.
Not where I thought we were going with this. I thought I was going to be the one to vote no. Malice.
Now you get to vote yes.
I'm going to vote yes. I don't want to, but I voted yes. I don't want to see this used as precedent, although we have no way to.
We won't tell anybody.
To prevent that in the future.
It's hidden by the trees. No one's going to see it.
Like I said, I don't know how my colleagues view this one, but I wanted to see this as a variance, but that would be unfair to deny and then make you come back and spend a lot of money coming back to us. And that might not even work anyway. So, thank you. Good luck.
Thank you very
so
much.
much.
I
Thank you
ran.
so much.
Motion passes
3-2.
3-2 for the alternative resolution. Ms. Klein, can you call the next one?
Yes. Case number V-12117-26-UP-2, a use permit request by Timothy Robinson on behalf of Naral Merchant and Lindsay Stevenson, the owners, to permit a street setback of 18.9 feet to the building eve instead of 19.9 feet to the building eve from North Granada Street as previously approved by the BZA in 2025 regarding after-the-fact relief from the building eaves of a one-story addition to an existing one-family detached dwelling on a corner lot in the R6 zoning district on the premises known as 382 North Edison Street, Arlington Forest. Staff recommends that the board adopt the attached proposed resolution approving the use permit request, subject to the listed conditions.
Do my colleagues have any questions for staff? Before we call the applicant up, I just want to disclose that I am friends with a homeowner a few houses away from this one, but he has not provided feedback in the materials, and my relationship with him will not affect my my decision in this case. Ms. McCuskey.
Yeah, I do have a question for staff. So what was the status with the drawings? I guess I was a little confused about how this came up, about the 2025 plat drawings. Did they show the eaves?
So I can answer the questions and then the applicants can fill in any additional details. The drawing shown on the left on the screen here was what was previously approved. It identifies the dimension of the setback at the amount that was previously approved, which is 19.9 feet to the building eave. But then ultimately upon construction and ultimately, I believe the final wall check plat being submitted for construction associated with the building permit, it was identified that the eave was built in accordance with what they assert are the correctly dimensioned plans, but essentially the label of that eave was incorrect. That eave setback was incorrect. So it was dimensioned to be 19.9 feet to the wall, but it's actually 19 feet to the, 19 feet to the 0.9 feet to the eave, and it is in fact 19 feet to the eave.
Okay, 18.9.
18.9.
Yeah, that's fine. That's fine.
A little bit of a
I'm just
buffer.
trying to get to the numbers I
sorry.
was on here. Okay,
Was that-
thank you.
Was that a way of saying it was a construction error or a
Label error.
label error? And
That is.
what BZA didn't catch that?
Mhm.
Just saying. Back a year ago? No, no, I'm blaming us. Like normally that's something we would catch.
Right. And Ms. Klein is the only one who can say she
Right.
wasn't here for. it.
Right. No, like what was that BZA doing approving this in the first place? Just saying. Is the applicant with us?
Yes, sir. I'm here. Timothy Robinson.
You want to speak to your application?
Similar to your sentiment just a second ago, I don't know how I made the mistake of writing it the incorrect number of a 19.
Right, we can just blame you.
Who's speaking?
Honestly, I would like to take the blame
The
and
applicant.
just
The owner?
move to, not the owner, I am the design professional who submitted the drawing.
Thank you.
Oh,
You're Mr. Robinson.
Mr. Robinson, correct.
Thank you.
Yep. So as it was detailed, we incorrectly listed 19.9 on the modified plat for the eave, whereas it should have been, when it came down to all the geometry and actually drawing it out, 18.9. And so we're going back now to rectify that mistake. It was only found to be a mistake once the addition was built in conformance with the actual plans, which showed visually what was on the plat, just not numerically properly shown.
Thank you. Questions for the applicant? Motion? Ms. McCuskey.
I move that the Board of Zoning Appeals adopt the attached proposed resolution approving use permit V1211726 UP2, subject to the listed conditions.
UP1? Oh.
Oh,
I
sorry. In
see.
the motion, it says UP2. Is
right.
it 2 or 1?
It's
Second.
Oh, you're right. Wouldn't this be 2 because it's the second?
It should be 2, which is what I said in the
Right.
motion. Yeah.
Wait, I'm sorry, can someone repeat a second?
Second.
A motion by Ms. McCuskey for approval as advertised, seconded by Ms. Freshman. Is there any further discussion? I'll just say I'm thankful that this still is, established compatibility by staff and that it's an easy approval. Unlike sometimes we see these and it's a lot more difficult. Hearing no further discussion, I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. McCuskey.
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion passes 5-0. Enjoy your eves.
Thank you all for the time.
Ms. Klein.
Case number V-12118-26-UP-1, a use permit request by Peter Vanderpool on behalf of Jordan Mariah, the owner, to permit a right side setback of 5.5 feet to the building wall, 4.7 feet to the building eave instead of 8 feet to the building wall, 5 feet to the building eave as required, regarding a new one-story addition to an existing one-family detached dwelling on a corner lot in the R6 zoning district on the premises known as 1520 North Highland Street, Lion Village, BZA R26-00019. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Anything for staff?
Um,
Ms. Malish.
Maybe I'm just having difficulty tonight. Was there a plat showing the improvement?
There should be. Let me look and find that for you.
Page 14.
Thank you.
Does it, I don't see the improvement. It's both say
Says
patio.
proposed one-story addition.
So I see patio and patio.
There's a little square. It's actually in the screen here. You can see the highlighted yellow area is kind of
Oh, it's
helping call that out.
patio.
Yes.
Yeah.
Oh,
Yeah, I think it's existing as a patio, but it would be this proposed addition.
okay. I was looking at the wrong patio because there's two.
Is the applicant with us?
I'm Peter Vanderpool, the architect for the applicant.
Can you try and speak into, either raise the podium or speak into the microphone? Thank you.
Peter Vanderpool, the architect for the applicant.
Thank you. Would you like to speak to the application?
I don't have too much to add. I know the concerns of the county with the neighbor notification. We had sent letters to all the adjacent properties, but also wanted to point out that the neighbor that would be most affected is a vacant, the house is vacant and has been. Miss Jordan's a new resident in the neighborhood. She purchased this property at the beginning of the year. And that the lot, which is listed 3108, was vacant when she bought it and remains vacant today.
Thank you. Ms. Malice.
So you have no support that you can provide for the neighbors?
Nothing. We sent the letters to all the
So-
adjacent and neighbors as well.
Our expectation, I know you have another case here, is that you actually find an effective way of communicating with the neighbors where they will give support.
Yes.
And that's missing.
We had sent the letters, as I mentioned, the most affected adjacent property is vacant and the one to the south, the other adjacent property is a rental. We had sent the letters to the,
So most applicants will go door to door, talk to their neighbors.
Miss Jordan, as I mentioned, she's a new neighbor here and has a very demanding travel schedule.
Yeah, I'm not inclined to support this without neighbor outreach. So just letting you know up front.
Thank you, Ms. Malice.
I
Ms. McCoskey.
Question, why, I guess, is there a reason that this, it seems like a small addition?
Yes, it is.
And why is it placed here? As it seems like there might be places where it wouldn't cause a problem, but so is there a reason that it was designed to go here?
Yes. So there have been additions to the house over time, but as you can see, there's a stair. There was an addition that just down from the addition proposed, that is also an addition to the house done by the previous owner. And that's the transition point. So there are stairs that go down to the basement and up to the first level. And so Ms. Jordan wanted to get the laundry out of the basement and then have that additional space available at that transition area.
Anything further for the applicant? I'll say I am also troubled by the lack of outreach here, because I think we have a second one as well with similar lack of outreach that we'll, address shortly.
I don't know about my colleagues. I would support a deferral for the applicant to find an effective way of getting neighborhood feedback.
I'm seeing some nodding heads, so I don't know.
What, how would the applicant feel about a deferral to try to get some more neighborhood feedback so that some members of the BZA would be happier to consider this favorably?
Well, of course, a preference would be approval. And given the, as the addition is center of mass on the back of the property, and as I mentioned, the most affected neighbor is not available, we prefer approval, but would accept if the board would prefer a deferral.
I think it's a minor incursion on the property, given all the givens, but we do have we're pretty inflexible about neighborhood outreach. So I think that even though it isn't a dramatic change, the fact that the property owner behind it may not be there at the moment doesn't change that, other than the fact that you may not be able to reach that person. So I would support a deferral. I think it would have to be September.
I mean, it is a minor incursion, but it is pretty close to that neighboring property line. That's my concern.
Exactly.
And I don't know if the current house is a rental or not, but I think that owner still needs to be consulted, and there are ways to get that address and contact information.
Could it be July? Just a 1 month deferral, because it's not going to change drawings.
I defer to staff on that. Typically, that's too tight, but maybe not this time.
I would note that in the instance where there's absolutely no change to any type of design, and it would just result in additional submission of neighborhood outreach documentation and the resulting communication, that would be fine for July.
What would be your advertising date? Or you don't have to have that information by the advertising date?
Yeah, we have the benefit of this month being a little early, so we do have one extra week between. Advertising would be for July 15th, the 1st and the 8th, so we have a bit of time.
Okay. Mr. Chairman?
Ms. Malice?
Let's get back up here.
May I ask the board what would be, regarding the rental property and the vacant building, what would be the board's preference for neighborhood outreach?
So it would be contacting the owner of record.
Oh, in addition to the letters we've sent to them?
Of soliciting a response. So, yes.
What would that include beyond what we had? We had asked them to either support or oppose.
Okay, so hopefully they'll respond if you follow up with them and tell them that it's urgent. But you also have other neighbors that presumably are in those houses that you can bring back support. Because we're looking at land disturbance. We're not looking just at the next door neighbor per se, but everybody in the radius. When in the application process, there's a box that you check that says you've read the requirements for neighborhood outreach. Those are posted on the website. So I think if you refer to those, that page, it will outline what your requirements are.
And it's not just the two adjacent properties. It's
Yes, no,
the whole
we had sent to more than
Right.
just the adjacent properties.
So
Yeah, it says there's documentation of outreach to 9 neighbors. But there haven't been any responses.
Not that, no. That I've
And
seen.
is the rental and the the empty house, are they local owners?
The rental, I believe, is in Northern Virginia, and the house that's for sale, I don't know. I mean, it's the current owner would be local, because I only remember one that.
Because I can't, when I zoom in to look at the pictures, it's too pixelated. I can't see the addresses. So I have no way of telling where these were sent, right? It's just too pixelated. I can't read it.
So if you look at the other submissions, for instance, in tonight's agenda, you'll see that some people do petitions. You know, they've gone door to door to get petitions from the neighbors. Others have, you know, asked each neighbor to sign, bring a letter and have him sign. So there are multiple methods for doing that, but just sending a letter isn't very effective in getting a response.
And for the absent, the vacant property and the rental property, what would you consider acceptable there?
An additional outreach.
So additional letters.
Yeah, yes, with some, requesting some urgency. But if we.
Staff can advise you.
Yeah.
We don't need to get into all of it.
So motion, in case V-12118-26-UP-1, I move that the Board of Zoning Appeals defer the matter to our July hearing.
Second.
A motion by Ms. Malice for deferral to July.
July 15.
July 15th?
1-5.
July 15th, seconded by Ms. Freshman. Any further discussion? Ms. Malice?
Aye.
Ms. Freshman?
Aye.
Ms. McCoskey?
Aye.
Mr. Kumano?
Aye.
Chair votes aye. Motion passes for deferral till July 15th. Ms. Klein?
Case number V-12119-26-UP-1, a use permit request by Carter Jones on behalf of David Bunch, authorized agent for the Margaret Armitage Kelly Trust, the owner, to permit a street setback of 19.4 feet to the roof eaves along North Vermont Street instead of 21 feet as required regarding protruding roof eaves to a second-story addition atop an existing non-conforming footprint, a one-story and basement addition, a street-facing porch, and a new driveway to an existing one-family detached dwelling in the R8 zoning district on the premises known as 2400 North Upshur Street, Donaldson Run, BZA R number 26-00029. Staff recommends that the board adopt the attached proposed resolution approving the use permit request with conditions. Note there is supplemental material for this case that was provided to the BZA after the initial application packet was distributed with an email from the applicant regarding neighborhood outreach efforts.
Thank you, Ms. Klein. Ms. McCoskey?
So, as I understand it, the issue here is simply that the eaves are the only problem because otherwise they could build over the first floor.
Correct.
Okay.
Is the applicant with us?
Yes.
Would you like to speak to your application? Is the applicant still with us? If the applicant is online, we can't hear you.
Hello?
There you go.
Can you hear me?
Yes. Would you like to speak to your application?
I don't know if you can see me. I am trying to speak, but I don't think I'm being heard.
We can hear you.
Hear you.
I don't think the applicant can hear us.
Yes, I would like to speak to the application.
Go ahead.
I might need to call in.
No, we can hear you.
We can hear you.
I don't think the applicant can hear us.
For the record, I lived for many, many years at 2411. So I do know this property.
Ah. And you're still here.
and one of my neighbors is still there and signed.
Welcome to the audio conferencing center. Please enter a conference ID followed by pound.
We're gonna have to mute. Can you mute? Thank you.
Hello, this is Carter Jones.
We can hear you now.
Okay, let me mute my computer. So I'm having some audio problems. I'm not sure why. My name's Carter Jones. I'm the architect for this project. And David Bunch, the homeowner, is also attending. We submitted this project for permitting, and when we got the review comments back from zoning, we learned that surprising to us, if you look at the site plat, that this is not a corner lot. And so we were advised that we needed to make changes to the survey based on different setbacks, and we also were advised that we needed to submit for a use permit for the eaves on that one side, just the left side of the house. And so we put the use permit application together and submitted it to the zoning office so that we could hopefully move forward with the resubmission of our building permit plans. Secondly, I received an email from the zoning office not too long ago asking about 2 adjacent homeowners in neighbor outreach. I'd like to just let the board know that we did a great deal of neighbor outreach. I personally went by homeowners' homes, as did the homeowner. And one homeowner who didn't respond, I spoke with her twice, and she said she was busy on business calls, and please leave me a copy of the letter and the plans, and she'll look at it. David Bunch stopped by and left her a copy, and she still hasn't responded. The other home is, which is adjacent to David Bunch's home, is at 2407 North Vermont. And that house appears to be vacant. I've been there twice. David said he stopped by. There's a lockbox laying by the front door. The mail's filled up in the mailbox, and there are bags of trash in the driveway. I also sent a letter to the owner of record in California, and we have heard nothing from them. So as I understand it from the zoning office, those were the only 2 neighbors that they were asking about at the end.
Thank you, and thank you for your outreach. Do my colleagues have questions for the applicant?
Just a question for staff.
Go ahead.
So why is it, I mean, the ordinance allows you to build to the wall, but doesn't allow for any eaves at all?
The ordinance specifically says, yes, that the encroaching wall can be built vertically up above, but no encroaching no further than the existing wall itself. And so the eaves are not included in that, of course, because they encroach further than the existing wall itself, and therefore are not subject to that same exception that's in section 1624E5A of the zoning ordinance.
Even though the existing house may have eaves too?
Correct.
Seems like a draft.
It would seem like you would allow encroachment equal to the existing eaves, right?
Because the text in the zoning ordinance specifically says wall, does not extend to the provision to eaves.
And I understood you did it correctly. It's just, it's kind of illogical to ask someone to come for the eaves when 99% of the project is conforming.
Motion,
Please,
put it up. Thank you.
if you're volunteering.
Case V-12119-26-UP1, I move Board of Zoning Appeals approve the attached proposed resolution approving the use permit, subject to conditions listed.
Second.
A motion by Ms. Freshman for approval as advertised, seconded by Ms. Malice. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice,
Aye.
Ms. Freshman,
Aye.
Ms. McCoskey,
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion passes 5-0.
Thank you very much.
Next case, please.
Case number V-12120-26-UP-1, a use permit request by Peter Vanderpool on behalf of Joshua and Charlotte Campbell, the owners, to permit a street setback of 23 feet to the building wall along North Hertford Street instead of 25 feet to the building wall as required, to permit a rear setback of 5 feet, 4.6 feet to the building eave instead of 10 feet to the building wall, 6 feet to the building eave as required, and to permit a side setback of 4.3 feet to the building wall to 4.2 feet to the building eave instead of 8 feet to the building wall, 5 feet to the building eave as required, regarding a 2-story rear addition to an existing 1-family detached dwelling on a corner lot in the R6 zoning district on the premises known as 3135 17th Street North, Lion Village, BZAR 26, number -00026. Staff recommends that the board adopt the attached proposed resolution denying the use permit request with conditions. An alternative resolution has been provided should the BZA see fit to approve the use permit request as advertised with conditions. And note there is supplemental material for this case that was provided to the BZA after the initial application packet was published, and that includes an email from the applicant regarding neighborhood outreach efforts and 2 emails from supporting neighbors.
Thank you, Ms. Klein. Can you help me understand the garage in this case? Why is that garage as existing non-conforming? I think there was a line in the staff report that says the existing garage is non-conforming.
Meg, can you speak to
Sorry,
that?
wrong
Or-
person.
Yeah, let me look it up real quick. The setbacks.
'Cause I thought that there was garages can be placed closer to the property line if it's 1.5 stories or under and under a certain square footage.
It's the corner lot, I think. It doesn't meet the 10-foot rear setback
Thank you.
where it can have the 1-foot side setback. It needs to be at least 10 feet from the rear, which it's not.
Thank you. That was what I was missing. So if we're bumped to the side or up, depending on which one is that setback? On it?
That's the,
Is it the longer one or the shorter one?
So this would be the true front 17th
Right.
Street North. So this would be the associated rear.
So if
And
it
this would be
were-
the side street and also the other side property
Right,
line.
right. So it doesn't look like there'd be much ability to place in detached garage in conformance then. So okay, thank you.
Mhm.
Probably not helpful to the case, but I had saw that and wanted to figure that out.
Could you put that back up for a sec? So where the garage would be properly placed if it was 10 feet from the rear lot line?
That's correct.
Because that's
Because it's a corner lot.
because it's a corner lot. And from the side,
It could be 1 foot.
from the right side, it can be 1 foot. It's just 10 foot on that. Okay. Thank you.
And I'm assuming that garage was probably built by right when it was built.
I don't know when it was built,
Right,
but
but
it's,
I think that's probably a safe assumption. Okay. Do my colleagues have anything else for staff? Is the applicant with us? Would you like to speak to this applicant?
Can I
Wait,
ask?
1 second. Yep, go ahead.
Maybe it's, so the house that currently has dormers. Is it considered a 2-story house right now? Because it said it was a new 2-story addition and I just,
The addition itself would be 2 stories. It appears as though, Meg, you know this property better than I.
I think it's an existing 1.5 story and they're going to go above the existing house.
so currently it's 1.5.
Currently it's 1.5, but
Okay.
proposed in between to connect the garages, a 2 stories over a basement.
Okay. That's
Okay.
okay. Thank you.
All right. So now we'll hear from the applicant.
Hi, I believe this thing is on. I'm Josh Campbell. My wife is also attending virtually. I can add.
Can you just pull that a little closer to you
Yes.
to make sure it picks it up for
Is that a
people
little
listening?
better?
out? Yeah, that's better.
It was a house built in the 50s in Lion Village, and we've just been slowly updating it. So this is how we purchased the property, with the attached garage as is. We did not add it. So that is when it was built, and I don't know what the zoning ordinances were at that time. But there are many houses that have it very close to the property line in that way in Lion Village, because it was just built so long ago.
Okay.
So essentially what we're trying to do is just not tear down the existing garage and just add on top of it. I believe 1.5 story technically on the garage is something that would be in compliance, but rather than, break it all down and start from scratch, we're trying not to waste. The goal of the renovation is to get our laundry room out of our basement and just add additional space, as we have a 18-month-old for our growing family.
Okay. Is there anything else that you want to add to or Mr. Vanderpool, but just get close to the mic if you could when you speak. That's all.
I don't have anything to add, just to answer any questions you
Okay.
might have.
I do have some additional outreach that has come in quite late, unfortunately, that I'm
Okay.
happy to provide if you guys are.
Or here. Yeah. Okay.
And while he's walking around, this is Charlotte Campbell. I'm the other owner and wife of Josh Campbell. We did door-to-door outreach. We're very close with all of our neighbors, and we have received unanimous support and very positive feedback on the project. And I believe several emails have also been lobbed into the group. So happy to report that, and happy that we live in the neighborhood we do, because we love our neighbors and we love our neighborhood.
All right. Thank you. Do members of the board have questions for the applicant?
So I really have questions for staff
Okay.
when we're ready. Thank you. I have a question for staff. I was just looking to see which staff. It's Miss Ryan's project. Okay. Was the staff recommendation entirely based on the proposal for the garage?
The staff recommendation that where staff could not find compatibility related to that first finding was related to the rear setbacks, right? With specifically this addition becoming a 2-story. There was that one comparison of a 1-story kind of attachment that was as closer. But in this case, this is just staff found a different kind of resulting massing and scale than that one example in the neighborhood that we could find.
So are you saying it's compounded by the other setback requests?
There's quite a few setbacks being requested, street, rear, and side, because they're connecting it to the main dwelling. So the setbacks kind of change compared to just a detached garage. For example, the side goes from, for the 1-story detached garage, it goes from a 1-foot side setback to now an 8-foot side setback. So that kind of changes. And I couldn't find rear setbacks for a 2-story wall as close as they're requesting. And I also couldn't find a combination of the street, rear, and side. Even though I can find main building footprints as large as they currently requesting, I couldn't find the setbacks.
So, because the overall massing is pretty large, with everything going down the side of the street. So that's kind of a factor there.
Okay.
The rear setbacks, I'm assuming that they're not corner lots because they're bigger than 10 feet. Is that not a good assumption?
I use corner lots in my analysis because I put that at the top of the table, corner lots, just because if it was an anterior lot, it'd be a 25-foot rear setback compared to corner lots are 10, or require 10-foot.
I don't see that same distinction on, oh. Sorry, I was looking at the wrong table. Withdraw that.
So, so I guess a number of things would need to happen for staff to feel more comfortable with this project.
I think the proposed setbacks for the 2-story were just kind of not comparable with what staff found.
Yeah.
And may I ask a question, or should I wait? Sorry. Is it because it's the 2-story over
Oh,
the?
don't ask staff.
Oh, sorry. Is it because it's
Sorry.
consider
Ask
the
him.
2-story over the garage? Is that the big one?
Right, so I missed your presentation because I had to step out for a second. But my sense is that you want to build over your garage, which is already really close to the property line. Right, and so it's a combination of the garage is already really close to the property line and you're building on above it. And so those two, I don't think staff found a 1-story comparable to where you are now, and then you want to create that even higher up. Right, so you're taking something that is not comparable right now and you're making it less comparable.
As something, if it would be more consistent with the neighborhood, a 1.5 there would be perfectly fine with us as well. It's more just about not tearing down the existing structure.
Wait, so when you just for clarification, when you say 1.5, meaning you're just redoing the roof on the garage? I guess I don't know what a 1.5. What's a 1.5?
I think you might be able.
1.5 story.
So what would that look like?
I believe that is just a requirement of where the roof rafters sit relative to the pitch of the roof. It has to start within 2 feet.
Yeah, there's a distance above the floor. The rafters have to start, and then there's also allowable
So my
dormers.
my sense is that staff would still find that not compatible because they're not finding anything compatible with the garage as it is, right? So then adding another story or half story, which is really a story on top of it, I'm not sure that
I thought there was
helps.
a story and a half noted by staff as being somewhere in the neighborhood.
3145 17th Street North. There is a 1.5 story building wall 5 feet from the rear setback.
But I'm assuming that does not have the same other encroachments that you're asking for as well. I'm still struggling to find that.
I could not say.
I don't know. I don't know if that helps my colleagues get to a yes here. I don't know.
I don't think I'm going to get to a yes on what's been proposed. So the question, and so the question is, where do we go if we don't have consensus on that?
I think people are studying at the moment.
So, I'll just say overall, I think there's a lot of massing down the side of the street, by building up the garage, by enclosing the area, the space between the garage and the house. And then, the house going up as well. So that, that's an impression that I have. How to But specifically, it is concerning that we would build over a non-conforming garage. I don't think I could support that.
Thank you, Ms. Malice.
Again, this is Charlotte, and sorry, I'm trying not to speak out of turn, but, we really are just trying to add just additional space so we can enjoy and stay in the home. I think similar to an applicant a couple of houses ago during the same meeting, we're trying to figure out the right spot to add this room. And there is this space between our house and the garage that allows to us to add this addition, add the laundry room and some additional space so we can stay and grow in our home. And as you can ask our neighbors and see around, we've been trying to pay homage to the historic nature of the home without trying to tear it down or redo stuff. And, we are just trying not to waste what's already here by having to, tear something down and rebuild for a few feet. So I just plea with that. If you guys can come think about some other, we can happy to discuss other solutions, but we just don't. And I think people were worried when we moved in that the house was going to be torn down and rebuilt, and we're not trying to do that. We're just trying to create some additional family space. So that's all I'd add.
I mean, so we are not in the business of like proposing to you about what you should do with your house. I mean, that being said, the most of the discussion I've heard is about building over the garage. And so I think that is probably the majority of the opposition that you're hearing is building over the garage. Because if you don't build over the garage, I don't want to say, 90% of this can be done by right. I still think that you would be asking for small encroachments into the front and or back. But I think the major encroachment you're asking for is on the side. I guess the back, depending on how you look at it.
Do we have a photo of the existing from Hartford Street? Yes, thank you. So we're talking about a 2-story on the existing house, a second story, as opposed to what we see now. Is that correct?
On the existing house, it wouldn't go up at all, right? Like we're trying to make it look like it's as it is, just connect it to the garage.
Yeah, the
But
street
then the
facade,
space between the existing house and
The existing house is going up 2 stories.
Yeah, that's what I saw, 2-story
Correct.
addition.
It's definitely going up 2 stories unless I'm looking at the wrong application.
not any higher, because of its a narrow width, it's not any higher than the existing. And we've retained the street facade. And all the massing is going to be back from the side street.
So the front facade will look exactly the same,
Yes.
I don't want it to.
at the roof line, it will be 2 stories going back,
It's going to match the current roof in
but it's
back.
going to be 2 stories going back.
I think
In that back portion, there's already a shed portion at the rear, right rear of the house. And so it'll be matching that.
Do we have another picture showing that?
Oh, I see.
So, although technically that is I guess a 1.5 story. I mean, effectively it's a 2-story from a livability perspective. Is just to kind of continue along that line, out to the available space that could be possible, so that we don't tear down an existing structure and instead just keep adding to the house rather than.
When I look at the drawings, yeah, at the peak of the roof, you're going to go straight back, and it's going to be a full 2 stories. all the way to the garage.
Because of the width, the wider, if you have the same roof slope, the further apart the walls are, the higher the roof. So the existing house has a fairly high roof because it's width. We're having narrow width. So the new roof, even though it's 2 stories, will not be extending above the existing.
Right, it's not extending, but it's going to fill, there will no longer be that slope in the front. It's going to go straight back. I'm looking at your drawings here, or the elevations here. That's what it looks like. So it looks like it's going to be a full 2 stories all the way back
On that side property line.
on the side.
Right. Like I said, my sense is that the objection of this board is not so much the rest of the project, it's that 2-story garage.
Well, it's building over a non-conforming and then creating a solid mass.
Right, exactly.
On
Right.
Hartford Street
Right.
with no break.
Right. I think that's right.
For whatever it is worth, the neighbors immediately to both sides are in support of it. We've reached out to the neighbors on the corner across Hartford Street. They mentioned they were going to send an email. I believe they did. If not, they verbally told us they were in support of it. We spoke with the neighbors directly across that would be most looking on that. She's an elderly woman.
Even like just looking at this topical map, like filling in that area is going to really affect the massing of this property that is going to be unlike the others around it. And I think that's really the problem that I think is highlighted.
Mhm.
I believe absent the garage component of it, I believe we would, like, if we were to take it into pieces, I believe we would be largely within compliance. It's more just that additional garage piece.
That was my point, right? I mean, no, like that was the point I was making.
Yeah.
I think you might need something small, but you would be large. This is a largely by right project without that.
If I'm looking at these numbers correctly, you're about doubling the square footage of the house. It says main building footprint. I'm looking at the GFA. Building footprint.
If I can, the existing main building footprint is 1,236
Yeah.
square feet, and the proposed is 1,694 square feet.
Okay, what number am I saying?
Still a 50 to 60% increase.
Oh, I see. Yes.
Oh, you're right. I don't do math.
I'm looking and I'm scrolling sort of from what we have, the elevations, the ones at like page 25 through 27 of 24. And for instance, the pictures on page 25 and 26, it looks like above ground, it is a solid 2-story structure all along. Now, if you look at 27, there's some things that seem a little different, like if I look at the bottom picture on page 27 that has color in it, it looks as though there's a corner there that's a single story, but nothing, that's not what's shown on the ones above it. I'm actually having a little bit of a hard time understanding, because some of these drawings look like the big mass, which I think is what everybody's concerned about. And then these roofs look different in this picture. For instance, the corner that's under the chimney or just below the chimney looks like it's a single story porch.
That is correct. And that's already existing.
Right. But where, I just don't see that. Let's see. Oh, maybe because this is, but here's right elevation and left elevation on page 25.
That's the porch that was surfaced on. There was a cursor there just a moment ago. Yeah.
Mhm.
Where's that single story porch?
Right there. It's the cursor's on.
Sorry.
side.
Oh, okay. Oh, okay. Oh, I see. But then it's the roof above it that makes it look solid in this picture. But it's set, that's actually set back away. That roof is the shed roof. That's not at the front of the picture.
Right.
Okay, gotcha. All right, that helps me a little bit. Thank you.
I don't know, to try and further this along, I don't know where my colleagues are on this. I'm having a hard time with getting to an approval on this one because of that side of the garage being 2-story, 5 feet from the property line, while also asking for the other side relief at 5 feet as well. So we're asking to encroach into both 5-foot setbacks. And so I'm just making my position known for my colleagues, to help us get to where we're going here. And so I don't know where other people are here, but the garage. So if the garage stays in place, I don't know that I can approve something to build on top of that in that form, while also asking for the other side setback relief as well.
So are we looking at a deferral of some sort?
I don't know, right? Right. I don't know. I don't know what the applicant would want, right? Here, and I don't know if there are other people who support that position. I could be a minority as well.
My sense is that there are multiple issues that a deferral couldn't address,
I'm sorry, that could not address.
could not address. We're not talking about tweaking something or sending out additional outreach.
I would agree.
My sense is that there are multiple issues that a deferral couldn't address,
I'm sorry, that could not address.
could not address. We're not talking about tweaking something or sending out additional outreach.
I would agree. It's, I think, beyond the not parameters, but what we've deferred in the past. I think it's beyond that. And I think to a point you raised earlier, there's something here for them to be able to do somewhat or close enough by right, or closer to that. But I think this is beyond, coming down a few feet, I think. And I think since I've been here, I've kind of noticed when something has multiple asks or multiple different requests, that's always kind of been an issue for us since I've been here, and you're kind of echoing the same now. So I think just knowing that, I would agree that this is either it's a yes or a no vote from us, and I think it's better for the applicant that way. I think a deferral is not a guarantee that you come back and it gets approved. So you, in that case, may lose a few months of either doing this or doing something else. It's just, I think it serves everyone's interests better. That's just my opinion.
Yeah. The one thing, as I understand it, is that we have sometimes deferred to allow people to do some sort of redesign if they're going to have to come back, because then they don't have to pay for a new application. They get to to revise their old application, and it comes before us for deferral. Now, maybe this would be one where if they revised it, they wouldn't have to be before us. But that to me is why we've allowed applicants to defer to do some sort of redesign. We're probably looking at September though, because we don't have an August meeting.
Especially because of the incorporation of a non-conforming garage. I mean, I think that's making it even more complicated than just building a big addition that presents as ginormous to the street. It's more complicated than that because of the garage.
We may not charge, but we're not the only thing that requires a fee. And it's just something for the applicant. I mean, applicant, it's up to them, right? But
No,
deferrals are not a guarantee for anything.
No,
we
absolutely.
understand.
No.
We had a previous applicant who, we had a very similar discussion and then they came back with the exact same plan trying to argue their case. Right. And so if you come back with the same plan, you're not going to get a,
Yeah,
Right.
no, I think I understand where the concern with it being a two-story garage, and it not being consistent with the neighborhood.
Okay, given staff's input, and then we have universal approval from the neighbors, so I think the change cutting back would probably meet their approval as well.
Would that be the preference of the committee? That if we redesign, we get a new approval from the neighbors as well?
yeah, yes, you would still need, even though, they had,
The new plan.
yeah, because that's only fair because we don't want to then hear from a neighbor and you don't want to hear from a neighbor who's just, what the
Doesn't
heck are
look
you
like
doing?
that.
Right? We
Yeah.
like the one before, we don't like this, right? So
No,
it just goes
100%.
smoother.
We're very
It just
happy
goes
to do
smoother that way.
We're very happy to do that.
But and I'll just reiterate from my perspective of just me, I don't know that there's much that I would support with that garage going any more than what it is now. I understand that it is what it is now. And so I kind of caution that I don't know,
Okay.
and that's just me. I don't know where my colleagues are on that.
No,
So
that's
kind
helpful. Thank you.
Motion,
of- please. And I suspect-
case V-12120-26-UP1. I move deferral to September 16, 2026.
Second.
A motion made by Ms. Freshman for a deferral until September 16th, seconded by Ms. Malice. Is there any further discussion? Hearing none, I'll call the roll. Ms. Malice?
Aye.
Ms. Freshman?
Aye.
Ms. McCoskey?
Aye.
Mr. Kumano?
Aye.
Chair votes aye. Motion for deferral passes 5-0. Good luck coming up.
Thank you all for your time.
Ms. Klein?
Case number V-12121-26-VA-1, a variance request by Lorraine Deegan on behalf of Ambrish Gupta, authorized agent of 1517 Carlin Springs LLC, the owner, to permit a street setback of 27.3 feet to the bollards from the center line from First Street South instead of 50 feet to the structure from the center line as required, regarding the installation of accessory structures, bollards, in the C1R zoning district on the premises known as 17 South Carlin Springs Road, Glen Carlin, BZAR 26-00021. Staff recommends that the board adopt the attached proposed resolution approving the variance request. Please note there is supplemental material for this case that was provided to the BZA after the initial application pack was distributed in the form of one comment form from neighbor citing concerns. And please also note that we have an additional speaker who signed up to speak on this item from that same neighbor.
Ms. Klein, can you define what is residential structures and all structures, right? So would a parking curb be a structure? Like what makes a bollard a structure?
I would need to pull up, I don't think we have a definition
Sorry
of
to put you on the
structure
spot there.
in our zoning ordinance, but
I'm having a hard time with this case,
Thank you.
case.
we can
So,
pull it up.
And but structure and building are a little bit
right.
funky. It's about being, if it's attached to the ground like a bollard is, it's a structure.
But what about like a parking curb? Like what is a parking curb? Like one of those things that go in front of a parking spot
Oh,
that are low.
wheel stop.
Yeah, a wheel stop. Right? Like would a wheel stop be a structure?
I wouldn't want you to rely on my answer, but I would say no, because you just move it. You take in your,
But they're often dug
Oh,
in,
they're in
there's
concrete.
spikes in those.
yeah, maybe they,
Moving on.
I don't know. I don't know, but you have to ask the zoning administrator.
Thank you.
But in any case, I think, yeah. But the definition, basically, I think of structure turns on being attached to the ground.
I can read the definition of structure. It is anything constructed or erected that requires location on the ground or attached to something having a location on the ground.
So a sign would qualify.
Yes.
I mean, okay, I don't know.
Question.
Please.
So was there a requirement from the county standpoint to install these bollards?
No.
So there's no ordinance that says they must have a bollard or that it's required for safety or
It is
anything?
not understanding that a bollard is required for a parking space on site on a private parking lot.
No,
It prevents cars from going through the plate glass window.
I will.
And it
note-
allows for unacceptable advertising, which I agree with one of the comments of the neighbors.
I will note that the purpose of the change is noted in information submitted in the statement of justification from the applicant. And they can speak better to it.
But it's the county has no interest in,
We have no requirement.
it's no requirement.
Is the applicant with us? The
Hello?
applicant, is the applicant with us? Okay, the applicant is not with us.
Then we won't hear it.
Well, we can,
Well, we won't.
what?
Typically,
Sorry to
we don't
interrupt.
act-
I'm with Meckley Services.
Who is
Laura
he?
Deegan entered the permit for us. I told her that I would be on this call. I'm not sure why my name's not on here. Am I still allowed to speak?
I'm sorry, what is your relationship to this project?
We're the general contractor.
I'll note that she noted that the company that Laura Deegan also works for, so it sounds like she's a colleague of the owner's agent.
So you work for the same company of the person who signed the form, which is Laurie Deegan?
Yes? Hello? Are you still with
Sorry,
us?
it's cutting out. I'm working with Meckley Services, and we subcontracted Laura Deegan to submit these permits for us.
What is your name and company?
Catherine McAteer with Meckley Services.
Is that the name that's handwritten? No, Carlin Springs? No. Yeah, no,
We don't have
we
authorization.
don't have an authorization from the owner of this property for you to speak on their behalf.
Okay.
Is there anyone else that can speak tonight?
My name is Ryan Reed. I'm the person that lodged well, it's not necessarily a complaint I just want to make sure that.
Yeah, Mr. Reed, we'll get to you in a second. Let us just resolve this issue.
Sorry.
So I don't think we can hear from this person because we don't have any authorization from the property owner. Unless my colleagues feel otherwise. Why don't we hear from Mr. Reed and then we could go from there? Because it is a public hearing and he has signed up to speak. Mr. Reed.
Yes, thank you. Let me go ahead and put my all right. So, I don't necessarily have a problem with the installation of the bollards, just so long as they're doing it during regular work hours. A couple years ago when they did the paving, they did it at night on a school night, and essentially it kept us up. So I'm assuming that they won't do that again. The other issue is right now on the bollards that they do have installed, that they're installing or that they're placing cardboards, cigarette advertisement and stuff like that, which is, it looks poor. And I would prefer them to, I understand the reason to have the bollards because they're worried there's a lot of traffic and a lot of vehicles that are parking close to that area, and they don't want, a vehicle going into the side of the building. But, I just want to make sure the advertising is taken care of, and that's my only issue.
Thank you, Mr. Reed.
If we don't have a bona fide applicant, then I would suggest kicking it to July. But and I know there are rules about regulating content for signs and all that kind of stuff, but to the extent that we can make sure they do the work during business hours and don't put inappropriate advertising for across from the middle school, I would support that too, as our conditions, if that's permissible.
I would support that condition, although I don't think I would support this project as it is, because I don't think that this is in our purview to do, because I'm having trouble finding a hardship for bollards, and I also think that this is a reoccurring thing. Any convenience store in the county would want to can put in a bollard, and just because they haven't come before us doesn't mean it's not a reoccurring condition in the county. It just means maybe they haven't wanted to go through this process.
They did, sorry, they did put in bollards. There are already bollards in place in front of the storefront and in front of the sidewalk to the structure. So what it looks like, basically what they'd like to do is they'd like to extend those bollards to the brick structure to the side of the building.
Thank you. So I'm having trouble finding those two conditions for a variance. This seems like this would be for the county board to decide if they want to allow something like this to be added on. But I suspect I'm in the minority. Oh, interesting. But I also am a little uncomfortable without the applicant actually being here either, but I'm just voicing,
I'll make a
thoughts.
motion to defer.
Okay. Okay, go ahead.
I mean, you go ahead.
To me, I think, and I'm having a hard time understanding exactly where these bollards are going and what they're doing, but, and so I think it would be very helpful to have an applicant here who could explain it to us. So I'm
That's
going to
exactly
support
why we need
the deferral. But to me, I think there's a potential that it's, and because this is a safety issue, that there is and this may be the only location these can go to protect the pedestrians. It seems to me that it might be an unreasonable restriction not to approve the variance, and that because of the specific circumstances of this site, I'm not sure that there would be a general ordinance that could be approved, just like a setback or coverage. So anyway, I think I am going to support a deferral because I think it would be good to have the applicant here and have good information and so that we can really look at this.
I'll support a deferral too, but I'll also just, there's a lot of parking lots that have pedestrian walkways on them, like the parking lot right outside. There is not a bollard standing up in front of everything, and there are other solutions here, but that can be a discussion for next month.
They can defend it on July 15th.
Yes.
See, I personally am a no today. Next month doesn't really matter. Again, I seem to be very biased against deferrals, but I would be inclined to vote on this now because I'm a no. I don't see what the hardship is here, and I feel I'm still relatively new here. So I'm still trying to learn, but I've always kind of taken from you all that the bar for a variance is pretty high. So I don't see how this will ever at any point come close to meeting that for me. I don't know what the hardship is here. And this has nothing to do with what we do here, but this is a 7-Eleven across the street from a middle school. And I know what bollards are typically used for in places like this, and I don't feel comfortable with a middle school across the street. But again, that doesn't really apply to this, but just, I'm very familiar with this area. I live near it. So there's no pedestrians walking here. The local neighborhood is not frequenting this place and being endangered by the traffic from what I have experienced. So I have a lot of concerns about this. I do have some lines when it comes to stuff, and kids is one of them. So that's my concern.
Thank you, Mr.
Motion?
Mr.
Ms. Malice?
Yeah, I'm supporting a deferral because we don't have an applicant. And that's typically we will give the applicant one chance to actually appear before we rule so that we can hear from them. Ms.
Ms.
Freshman.
Freshman.
I move in case V-12121-26-BA1, I move deferral to July 15 BZA meeting.
Second.
A motion by Ms. Freshman for a deferral to July 15th due to applicant's non-presence, seconded by Ms. Malice. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice?
Aye.
Ms. Freshman?
Aye.
Ms. McCoskey?
Aye.
Mr. Kumana?
No.
Chair votes aye. Motion for deferral passes 4-1.
Out of curiosity, would I get a chance to speak again, or do I need to go through the application?
If
Okay.
if you get a consent form signed by the owner of the property, then you could speak. Right?
Well,
He's the speaker.
That's a neighbor.
Oh, I'm sorry. Yes. You are welcome to, if you sign up for it's a public hearing. If you sign up for the next hearing, you are more than welcome to speak.
thank you.
Sorry, I
We
couldn't tell who you were.
we can't see who you
Right.
are.
Ms. Klein, can you call the next one?
Yes, V-12122-26-UP-1, a use permit request by Robert and Melissa Malor. The owners to permit a right side setback of 6.2 feet to the building wall instead of 8 feet to the building wall as required, and to permit a total aggregate side yard width of 16.8 feet instead of 18 feet as required, with regard to a 2-story right side addition to an existing single-family detached dwelling in the R6 zoning district on the premises known as 989 North Quintanas Street, Madison Manor, BZAR 26-00024. Staff recommends that the board adopt the attached proposed resolution approving the use permit request with conditions.
Thank you, Ms. Klein. Do my colleagues have questions for staff? Ms. McCoskey?
Is this coming before us because they're making structural changes to the 1-story addition and otherwise they could build over it?
That, and I think they're also doing a basement below. So I think they're removing it, doing a basement, the first floor and the second floor.
Okay.
I think it's
but
being completely removed. So the first floor
Right.
walls are being removed. So then,
Right, but it's in the same location as it is today. And theoretically, if it were structurally sound, somebody could build over it
Correct.
within the zoning. Okay, thank you.
Yeah, but my understanding is if you tear it down, you're starting from scratch.
Correct.
Is the applicant with us?
Yes, can you hear me?
Yes. Would you like to speak to your application?
Sure. Yeah, as was mentioned, we have a enclosed side addition area right now. Looking to build a second story above it. And for structural integrity, we had thought to tear down the current structure and build 2-level structure in its place, as opposed to just building directly on top of it. We're also considering the basement, pending cost and complexity. It's currently an office and workout space without climate control. We're a family of 5 with 3 kids, so looking for a bit more space, making it easier to host family. It would maintain the same footprint as mentioned. So exact same footprint, just adding that second story above and possibly a basement level below. Reached out to all of our neighbors, 6 closest neighbors. All were unanimously in support of the project, and compatibility wise, seeing similar side setbacks and 2-story additions like we're proposing across the neighborhood. So yeah, excited to bring this in front of you, and thank you for your time. Open any questions.
Thank you. Do my colleagues have questions for the applicant? Would someone like to make a motion?
Mr. Chairman,
Ms. Malice?
I move that the Board of Zoning Appeals approve the attached proposed resolution approving the use permit V-12122-26-UP-1, subject to the conditions listed.
Thank you, Ms. Malice.
And
Second.
I will just say it was great neighborhood outreach. Thank you.
A motion by Ms. Malice for approval as advertised and praising the applicant outreach, seconded by Ms. Freshman. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice,
Aye.
Ms. Freshman,
Aye.
Ms. McCoskey,
Aye.
Mr. Kumana.
Aye.
Chair votes aye. Motion passes 5-0. Easiest one of the night.
Thank you.
Ms. Klein, can you call the next one, please?
Yes, case number V-12123-26-UP-1, a use permit request by Carter Jones on behalf of Laura and Samuel Brannon, the owners, to permit a street setback of 18.1 feet to the porch, 17.1 feet to the porch eve, instead of 21 feet to the porch, 19.5 feet to the porch eve as required, with regard to a new front porch addition to an existing single-family detached dwelling on the R6 in the R6 zoning district on the premises known as 633 North Illinois Street, Bluemont. BZAR number 26-00033. Staff recommends that the board adopt the attached proposed resolution denying the use permit request. An alternative resolution has been provided to the BZA to see fit to approve the use permit request as advertised, subject to conditions. Note there is supplemental material that was provided to the BZA after the initial application packet was distributed, and that includes applicants providing an alternative front porch design and 2 BZA comment forms in support. And in addition, we have additional speakers signed up to speak, including 3 speakers shown on the screen here.
Thank you, Ms. Klein. Quick question for staff. The survey is dated 2021. Can I assume that the deck under construction is complete? That's not
Yes.
part of this, right? So I'm assuming that the 2-story addition and the deck under construction have existed for some time.
Correct. Those portions in the rear are not considered part of the,
But I mean, they're not part of this, but they're also not under
considered
construction.
an existing condition.
Right. Thank you. Anything further for staff? Is the applicant with us?
I had
Ms. Miles.
I had a question for staff. So in the supplemental material, there's a revision. Has staff reviewed the revision?
There's an alternative front porch design that the applicant has provided.
The
You've
applicant,
seen the front porch depth from 8 feet to 7.3 feet.
Uh-huh.
and I would say that the applicant can speak to their intention behind it. They've indicated to us so far that they would like for the BZA to review and hopefully approve the initial design presented before the board, which would be an 8-foot deep porch. But they have submitted a supplemental item with a revised alternative design should the BZA not see fit to approve the porch as proposed and would be amenable to a reduced depth porch.
And have staff reviewed the proposal and have an opinion on it?
Staff has not had time to evaluate the proposal because it was submitted yesterday. And it would take considerable more time to do that. But I would say that staff would look at what the analysis, the staff report findings. I mean, there's that depth is now 7.3 feet as opposed to 8 feet before. So compare that against what's shown in the staff report.
Thank you.
Is the applicant with us?
Yes, this is Carter Jones. I'm the architect. Can you guys hear me?
Yes, we can.
Okay, I got my technical problems fixed. I'd like to thank the staff for working with us on this project, and I'd like to thank the BZA for your consideration. The homeowners are here, and both I and the homeowners would like to speak about the design at the appropriate time.
No, that is now.
Okay.
Yeah, this is
I'll
the
jump
time.
right in. Let me just as far as some background. I worked with the Brannons many years ago when they did an addition off the back, and one of their goals and objectives was to keep the low profile of the Cape Cod as on the street front, as far as the view of the house from the front of the North Illinois Street. And they at that time they had a large oak tree, which there's a picture of it in the package. It's with the statement of justification, and they lost the oak tree due to disease. And so when we started the project, their goals and objectives were to get some shade because the sun beats in the front of their house. They'd like to add shade with the front porch and help make it more energy efficient by blocking the sun. It's also a very street facing neighborhood, and a lot of families and kids are out front all the time interacting up on each other's porches and riding bikes and things like that. And so they wanted to create an outdoor space on the front of the house. We learned that there was an issue with the size when we got the staff report last week. And so I spoke with the zoning staff about this, and the Brandons and I got together to look at options. There are a couple things that are constraints on the design. The first is the front of the house has two large banks of windows, and on either side of the door. And the picture that's up there now, it's not their house. But there it is. And so we're kind of, to get a porch across the front of the house, we need to stay outside of those windows to accomplish what they're trying to do with getting some shade and controlling the solar heat gain. If we pulled the porch all the way inside the windows, they would have a portico and not a front porch. So when we started looking at what can we do to make this smaller, we pulled the sides in on the left side and the right side closer to the windows. And we also shrunk the front of it back a little bit to a point where the Brandons are comfortable that they'll be able to put their furniture out there and use it as an outdoor living space. So hopefully by reducing the size a little bit, that will help our cause. And we thank you for your consideration.
Thank you.
Mr. Chairman.
Ms. Malice.
Mr. Jones, you mentioned that the owners are with you?
Yes, they're here, or they're attending the meeting, and I believe they wanted to speak as well.
Okay.
Yes, we're here.
I'm only asking because this is just a dotting the I kind of thing, but you have a consent form for Mr. Jones to act as your agent that's not signed. So just wanted to verify that Mr. Jones is acting as your agent.
Yes, he is.
Thank
And
you.
I'm sorry for that. We definitely have a signed version of that form. We must have incorrectly or submitted the wrong file.
Mr. Chairman.
Ms. Freshman.
So am I to understand that the staff recommendation is for denial, and the suggestion has come that they reduce it in size, in depth, I assume. But we don't have any plans to that effect. Is that correct?
The plans are provided as a supplemental attachment to tonight's agenda for the alternative design.
So, but it's not a plan, the revision is not something that you've evaluated?
Correct.
Okay. So does that suggest that we defer it?
Typically, we would defer when we are given new plans and.
Because we don't design things in a live meeting.
Well, in this case, there are actual plans that are attached. And so then the question is, we have the setbacks in the report that staff found compatible. So I think in this case, it's probably up to us to make that determination. I suspect staff would still deny the revised because of the compatibility setbacks, but that doesn't mean we can't approve this if we want. And if this board, I would be comfortable going that route if based on the information we have.
Are you suggesting that we stop and review these plans now? The new plans?
I mean, I would never suggest my colleagues do anything.
No, well, I mean, is that where we're going? Because I'd have to sit in here. And look.
I think I could be swayed to support the revision. But I understand that I'm not sure how likely that is for my colleagues to do that. Ms. McCoskey.
I will give my usual grumpy answer to porches, which is that generally, the county allows front porches at a depth of 4 feet, and they can encroach into the setback. And people regularly ask for 6 foot, and this is at 7.3 or 8 feet. I have a concern about approving that encroachment into the setback when, the general standard, right or not, by the county board in the ordinance is 4 feet. So I'm just putting that out there. I think that my colleagues are more willing to go ahead and approve these deeper porches, but that's kind of where I sit. And that's the background of my not liking to approve these porches that are the standard in the county.
Mr. Chairman. I understand your point of view and usually disagree, but in this case, my concern is more for the fact that technically speaking, I don't think looking at a new plan that the staff hasn't evaluated at almost 10 o'clock at night makes any sense. And I would prefer that even though the change is modest and we could probably wing it, I don't think that's the way we roll. So I would prefer to defer it for a month and let everybody look at and as you say, the staff may still recommend denial, but then it comes back to us and we can make the exception if we so choose.
Ms. Klein?
I will just note that the agenda list for July is becoming quite lengthy.
Excellent.
And that is for this board to just consider. Food for thought.
September.
If I could just jump in here for a second, please. Let me introduce myself. My name is Laura Brannon. I'm the homeowner. My husband's here with me. One of the reasons why we want to get this project going is, as was mentioned, we lost a magnificent specimen of an oak tree in our front yard, and we'd like to get the porch built so that when the fall comes around, we can start replanting other native species and replace the tree, not just the single tree, but plant multiple trees. And the timeline of this project is going to determine whether or not we can meet the fall planting season.
Thank you. Miss.
We also had 3 additional speakers that have signed up that haven't.
Oh,
spoken
thank
yet.
you. Thank you. Let's hear from the speakers. Mr. Paris. I would have totally skipped them if you didn't point that out, Ms. Ryan. Is Mr. Paris here? Is Ms. Zucker here?
Hi, yes, I'm here.
Would you like to
Hi.
speak to this
Yes.
package?
Hi, Judy Zucker, my husband, Alan Zucker. We are the immediate next door neighbors who worked with the Brannons to save that beautiful oak tree. But we're not successful, unfortunately. We have a porch and our next door neighbors across the street have a porch as well. And we welcome the Brannons adding a porch so that all the neighborhood kids can enjoy it as well. It's our house dead ends, our street dead ends to the Bluemont Trail, and we have a little ring camera that we can see what's going on. And people sometimes when it rains take shelter on our porch, which I find very endearing. So we are all in support of the Brannons also adding a porch.
Are you the house to the left?
If you're facing the house to the left, yes. So you can sort of see when Carter
The
was
corner porch.
showing. Yeah, so we've got a porch also.
And this is Alan Zucker. I also submitted a online request to supporting the porch as well.
Thank you. Is Ms. Cochran online?
Hi there, this is Maria Cochran. Can you guys hear me?
Yes, we can.
So I live on the other side of the Zuckers, so 2 houses down from the Brannons, and we do not have a porch. And I can say that our living room is almost unusable when the sun starts, coming in. And so just the, impact that has on the heating and the cooling costs is terrible. And also, so it's just challenging. So anyways, we totally support the porch. A number of the homes on our street have porches, and I think it just adds to, the feel of community that our street really prides itself on. So we are in support. And also Dan Paris asked if you could unmute him. He said he's unable to unmute himself.
We can't, staff does not have the ability to unmute anyone.
Okay. Thank you so much.
There's a call-in number he might be able to use.
Okay. I'll see if
just
he...
let me just let me unmute. Can I speak? Is that okay?
Okay. Yes, go ahead.
Okay. So I've lived on the street for the last 20 years. We live a few houses up the street closer to Wilson Boulevard. Our house does not have a porch, but we are fortunate that we have 2 large maple trees that provide shade for the front of our house. Though when we moved in, we only had 1, and for the first 15 years, the front of our house would be, in the summertime, it's almost like you cannot sit in the living room, or you have to close your shades, and even then it's still very hot. I'm in support of the Brannons having a porch. There are already several on the street, though I have not taken a tape measure to any of them. All of them fit the character of the houses on our street, and as with the Brannons, I see the design. I think it's totally appropriate, fits the character of our street. There's, though they're not speaking tonight, on the other side of the Brannons, there's a house with a porch. So to deny it tonight or to push it forward to be voted on again, I don't really see the reason for that. Our street already has several porches on it already.
Thank you.
Thank you.
Mr. Chairman,
Ms. Malice.
were we working on a motion?
I mean, so it sounds like either we're headed for a deferral or we can entertain the revision plat, which is attached, and I suspect I know where we're going.
I would have been supportive of the revision tonight, and I would note that I do think it matches the neighborhood aesthetic and is compatible and has widespread support, where they live, which to me would give me what I felt like I need to get to a yes, but I'm probably alone on that one. And at which point I would defer just to, keep it moving for them. But my first choice would be to vote yes today.
Thank you, Mr. Kamana.
I agree.
Mr. Chairman,
Ms. Malice.
I'm often kind of a fence sitter when it comes to the porch things, and this I think really exceeds what was even remotely intended by the county board. The issue really is not with the BZA, the issue, because we follow what the county board has set out, and the county board has set out 4-foot porches. That's it. So coming in and asking for more, people are coming to the wrong place. They need to go to the county board and ask them to change the ordinance.
Thank you, Ms. Malice.
But if you all want to do a deferral, I'm happy to make that deferral motion, but otherwise I would not be supporting a motion to approve it tonight. What do you want me to do?
It's hard for me to read, which is why I never make motions. So if someone wanted to do it on my behalf of a motion to vote on this today, I would second it. I apologize, it's just vision disabled. It's harder to read.
Is anyone?
I didn't understand what he just said.
Are you inclined to make a motion to support tonight?
Oh, The revised one that
Yeah,
nobody's seen?
the
Okay.
revised one.
Yes.
Mr. Kumana said he would be inclined to either make the motion or second it, but he prefers someone else to make it
And I second it.
for Ms. McCoskey.
I'm just going to suggest that if Mr. Kamana wants to make the motion but the issue is reading and all, maybe Ms. Klein or Ms. Ryan could just read it on his behalf and then it's his motion.
Would that be okay?
Happy to do that. Meg, can you pull up the screen for me?
Which motion are you making?
But we don't have an alternative, so we would
The
have to,
original?
we would have to revise.
We would have to.
Yeah,
You have an
you don't
alternative.
need to read a motion ever too. If you want to just come up with something on the fly, you can always just say what you think.
I retract. It's fine.
Okay.
I don't think that anyone else wants to vote on the revision, so.
I'll make a motion to defer to our September hearing.
Second.
A motion to defer to our September 16th hearing made by Ms. Malice, seconded by Ms. Freshman. Is there any further discussion? We'll call the roll. Ms. Malice,
Aye.
Ms. Freshman,
Aye.
Ms. McCoskey,
Aye.
Mr. Kumana.
No.
Chair votes no. Motion to defer to the September 16th hearing passes 3-2.
Thank you.
We'll see you in September. One more?
Yes.
Ms. Klein?
Home stretch. Case number V-12124-26-UP-1, a use permit request by Sean Williams of Fast Track to Permit LLC on behalf of Aaron and Elise Margosis. The owners to permit a street setback of 20 feet to the building wall instead of 21.5 feet to the building wall as previously approved via variance V-6869-90-1, and to permit a street setback of 17.5 feet to the building eve and 10.4 feet to the stoop instead of 21 feet to the building eve and stoop as required with regard to a one-story front entry addition, new stoop, and new eve to an existing single-family detached dwelling on a corner lot in the R6 zoning district on the premises known as 1100 North Kentucky Street, Westover Village, BZAR 26-00027. Staff recommends that the board adopt the attached proposed resolution approving the use permit request with conditions. Note there is supplemental material for this case that was provided to the BZA after the initial application packet was distributed, and that includes owners providing a photo of the existing condition of the vestibule.
And do we have that picture?
This is the supplemental material that's attached on the agenda.
I thought you were referring to something else.
Sorry.
Yeah, no, I missed. Do my colleagues have questions for staff on this application? Is the applicant with us in the room who have been waiting here all evening? I've been eyeing you guys since,
notes.
it's always the one in the room who is the last one on a long night. That's how it works every time.
And I suppose you'll be applying to be a member now.
No.
So, is this your picture here? It's supplemental material. What was?
Yeah, that's his picture.
Is that from you?
And if possible, online, can we make sure that the microphone is turned on right in front of you here?
In front of you?
Yeah, thank you.
Yeah, we can't see that red light.
Sorry.
So
apparently I was on mute. Sorry. So Yes, in color. That's
Oh, I saw that.
daylight.
Yes.
Now, this has been caulked over, so it's not leaking right now, but this is not the first time that we had to deal with this. The previous owners added this on in 89 or 1889, no, 1989, 1990, somewhere in there, and they never properly attached it to the house. It continues to separate. You walk into that space, even with the caulking and everything, you feel the humidity because it's just not properly done. Our understanding is that the guidance that the laws currently on zoning and so forth, if we were to tear this thing down and build it up again with the exact same footprint, we would need a variance. So what we've decided to do as part of a slightly larger project is to make it a more usable space. The entire thing, the entire footprint has been awkward from the get-go. We hardly ever use the front door. So that's why we're looking for a bit more space and make the porch a bit more usable. If you look at a photograph of the front of the house, so the picture on the right is the proposed. Yeah, that if you come up to the front door and then open the screen door, you have to step down onto a previous step or off to the side. It's just a really, really awkward space. So we're trying to address those problems at the same time, as well as some other things. We're going to make the stairs a lot more compliant. We're going to actually tear out the concrete that's there. This doesn't apply. We don't need a variance for this from what I understand. So I could go into all those details, but you guys must be starving to death and ready to go home by now anyway. So if you have any questions.
Another porch.
And the staff, my understanding is the staff is recommending approval. So.
It's not a porch. I know, I was just. Oh, my iPad just died. But my recollection of the top line of the staff report said 21 feet. Is it getting the porch allowance? And I am embarrassing myself because my iPad just shut off.
The raised stoop would be, the requirement be 21 feet from the street.
Because a stoop qualifies for the encroachment from 25 feet?
You get the 4-foot encroachment, so the requirement would be 21 feet from the street.
So it was not just porches, it's also stoops.
Correct. And eaves and other things.
Right.
Yes.
Yeah. Okay, thank you.
Let's go.
Ms. McCoskey.
I have to say that I think this one is, well, what is this? I'm sorry. I'm sure somewhere it told us, what are the dimensions of this front stoop? So it goes further into
3.7 feet by, oh, wait,
Says
I think I'm reading what's currently
5.8
there.
8 times 10.
All right, let me find that. Okay, it would be 10.1 feet by 5.5 feet.
So, in the vestibule, so it's 5.5 feet deep.
Correct. Increasing by 1.75 feet.
Well, I may vote against it as simply the 4-foot rule that I've been sticking to. But I understand that this board has approved many 6-foot deep porches.
But it's a vestibule and a
Pardon?
stoop. It's a vestibule and a stoop. It's not a porch.
But the stoop is the stairs. Is that correct?
The stoop would be kind of like the raised patio, so the stairs would be separate from the stoop, but just the,
Right. But the walls is where the vestibule is that correct?
that's correct, yes.
That's a structure, not a porch.
But it has the same allowance to go 4 feet. I guess the stoop, maybe it's going further than,
Okay.
Ms. Mills?
Clarification. The stoop and the vestibule combined, what is that measurement?
Let me pull that up.
We don't have the stoop.
the stoop looks like it's 10.5 feet
Thank
from the
you.
front lot line.
I mean, I'm
At
looking
its
at
large.
distance from the face of the house.
And Meg, if you have it, feel
Oh,
free to say
But
too, but
this-
I'm happy to, as I find it. So it's hard because the stoop, as you can see on the right plat here, has like a curve to it. So the exact dimension of the stoop part is difficult. But it looks like the stoop itself is asking for 10 feet, 5-inch setback. The stoop is Meg, correct me if I'm wrong, the stoop is the uncovered portion of the platform that extends out in front of the vestibule that's proposed.
Yeah,
It's that portion, perfect, shown in the rendering here.
so here's like the raised patio portion of the stoop that is requiring the setback relief.
So the stoop is how deep? 5'5"?
No, the vestibule is 5.5 by 10.1.
The vestibule is 5.5. And the stoop?
If you 6 feet deep so 6 feet by 10.1.
6, and the stoop is 6 feet
Mhm.
deep.
So together with the vestibule and the stoop together are 11.5 feet. Thank you.
Can I ask a question? My understanding was that the covered area,
I was just
the
about to ask.
enclosed area was,
I was just about, because I am gonna
Mhm.
embarrassingly sit, my iPad battery died, so I don't have any of this in front of me. Is the stoop by right? Is any of
No.
this by right?
So the definition of stoop is a raised platform that serves as an entrance to a building, may be roofed, has no supporting posts, and is not enclosed. The stoop is allowed to have the same encroachment as a porch, which is more typical to what we see. So the 25-foot typical front street setback will be reduced to 21 feet.
Right.
So they're requesting encroachment for the stoop.
But this thing says it's a 10-foot something to the front of the stoop.
Yeah,
Right,
so that
and-
comes out to about 10.4 feet.
So are
Right.
we approving a 10-foot setback really?
10.4 to the,
Yeah.
that's what's currently proposed for the stoop.
Okay, I am struggling here.
Okay,
'Cause that's
so
not what I remember reading.
We can throw the language of the project summary back on the screen here for the group. I think that could be helpful.
so
And I'm happy to read it again too.
they're arguing that the vestibule is existing. So they don't really kind of count that, but they're making it a little bit bigger. And then they're making the stoop a little bit bigger from existing. So
yes.
what they're asking for is something in addition to what they have, but not 10 feet. You know, if they stay where they are, but the problem is when you tear that vestibule down, you start from scratch, and that's where. But on the other hand, we have in fact permitted people to tear things down, like the
And-
case before,
and make bigger.
and rebuild on the existing. So the question is, you know, is the additional space of the vestibule warranted? And is the additional space
Right.
on the stoop warranted? Now, the vestibule to me seems like, okay, you know, it's not very roomy the way it is. It's not very functional. Whether the stoop has to be that wide.
Right.
That's an open question. Yeah, the design would still work if the stoop wasn't, I guess the stairs might be more narrow if they're lining it up with the stairs, but it's a handsome design.
Much like the previous porch.
So,
Okay.
so
Although I would say there's some distinction in terms of just the amount of open space around
Exactly.
it because of the narrowness
That's
of
fair.
the stoop. It's not a wide porch that we're talking about.
Right.
Yeah. So I think it does functionally in terms of compatibility, it can be a little bit different in terms of whether it's compliant with the zoning policies, and my picky rules.
Does that mean you're supporting?
No, I said my
might
picky
be.
rules and my picky rules.
Right. Well,
It
I
might
thought
not
maybe
be,
you were
so.
changing, had a change of heart.
No.
So the stoop itself is 5'5" deep.
The stoop
No,
is 6
6
feet
feet.
deep.
It's actually 6 feet deep.
The vestibule is 5 feet.
Yeah, 5 feet. So if there was a hang up, it would be on the width of the stoop.
Can I explain a little about some of the thinking when we were making it that deep? We're taking out, if you go to the picture of the existing. Yeah, so the concrete steps in the front, we're taking those out. We want to be able to get things in and out of the door, right? And that requires, because we're on a hill and coming out of the door, we can't lower the door, the front door. I actually looked into could I come up with a way to do that? And it created all kinds of other problems. But we want to be able to take things in and out without creating hazards. And so that's why we have just, I think, a couple steps and then flat area. Wanted to avoid having too many rails and things like that to interfere also. That's what we were thinking when we did that.
Anyone? Silence.
I like it. I'm V 12124-26-UP1. I move that the Board of Zoning Appeals approve the proposed resolution. I'm tired. Okay. Subject with the conditions. Thank you.
Second.
A motion made by Ms. Freshman for approval as advertised, seconded by Mr. Kumana. Is there any further discussion? Mr. Kumana.
Yeah, I of course support this, as you can imagine. I just feel like we've completely lost consistency on kind of porches, and aside from you, of course.
No.
But we toggle between four and approving even sometimes in the same neighborhood. Because a lot of these come up where I live on the west side. So I'm almost inclined to vote no as a little small protest. I'm not going to do that. But we've just kind of lost consistency here. So I do want to note that. But I, of course, support this.
Thank you, Mr. Kumana. Hearing no more, I will call the roll. Ms. Malice.
Aye.
Ms. Freshman.
Aye.
Ms. McCoskey.
No.
Mr. Kumana.
Aye.
Chair votes no. Motion for porch passes 3-2.
Thank you.
And I just want to say, I think we're giving you a bad name, fast track to permit. I'm not sure you want to come back here. Fast track.
I move
His
approval.
company name is Fast Track.
I
Fast
move
Track to Permit.
approval of the May 20, 2026 work session and May 20, 2026 BZA hearing.
Second.
A motion for approval of the May 20, 26 minutes made by Ms. Freshman, seconded by Ms. Malice. Any further discussion? Hearing none, I will call the roll. Ms. Malice?
Aye.
Ms. Freshman?
Aye.
Ms. McCoskey?
Aye.
Mr. Kumana?
Aye.
Chair votes aye. Motion for minutes passes 5-0. I believe we have one more item on the agenda, Ms. McCoskey.
Yes. I move that the BZA approve the amended and revised bylaws as included in the agenda materials.
Second.
A motion for approving the amended bylaws as in the hearing materials made by Ms. McCoskey, seconded by Ms. Malice. Is there any further discussion? Hearing none, I will call the roll. Ms. Malice?
Aye.
Ms. Freshman?
Aye.
Ms. McCoskey?
Aye.
Mr. Kumana?
Aye.
Chair votes aye. Motion for minutes passes 5-0.